One.
Good morning, ladies and gentlemen. Welcome to the March 26th meeting of the Board of Oil, Gas, and Mining here in Salt Lake City. And we're going to get started right away here. We have a couple of things early on the agenda. The first of which is, Mr. Borden, could I have you come up front here? For the audience, Mr. Borden is leaving the board, and I write everything down so that I get it correct. I just want to say, Richard Borden was appointed to the Board of Oil, Gas, and Mining in March of 2015 and has served diligently as both a member of this board and for a year as its chairman. With his 35 years of experience in mining matters, Rich has filled the required position under the statute for the mining representative. The board has appreciated Rich, has appreciated your expertise, your friendship, and your service for these past 10 years and wishes you the best. Thank you. We have a couple of gifts here as a remembrance of those 8 or 10 traumatic years. And thank you so much for your service, and good luck.
Thank you. And I'd like to say I have really enjoyed it. I've enjoyed the challenges of being on the board and chairing the board for a year, and I've enjoyed working with all of you. I mean, many of you in the room here. We've been working together for the full 10 years I was on. And you'll never notice I'm gone. Pat James, my replacement, is going to fill the role admirably, I'm sure. So thank you.
We will never forget. We'll never forget you. Thanks, Rich.
Thanks.
Yes, yes.
Our next order of business will be the swearing in of Rich Borden's replacement, Mr. Patrick James. We also have some re-swearing of 3 of our board members who are renewing for another term. We have Gordon Moon, Selma Sierra, and Al Walker, who is currently our vice chair. So could I have the 4 of you come forward to the front of the podium?
I'll shoot it. Update from where? 30 seconds.
Yeah, face this way. My name's Nathan Schwabach. I'm Deputy Director. Joel Ferry's unable to be with us this morning, so I get the privilege of doing this. And for the 3 current board members being sworn in, congratulations. We've appreciated your service. And for Gordon joining the group, we're thrilled to have you. We appreciate everything the board does for industry, for the division, and the good work there. Rich, where did Rich go? Yeah, appreciate you. Thank you for your contribution and all that you've done for the board and the division. If you could raise your right hand and then repeat after me. I state your name. Having been appointed to the Utah Board of Oil, Gas, and Mining, do solemnly swear that I will support, obey, and defend the Constitution of the United States and the Constitution of the State of Utah, and that I will discharge the duties of my office with fidelity. Congratulations.
Thank you very much, Nathan. Appreciate you doing that for us. And welcome back to the board. And welcome to the board, Mr. James. Perhaps you could just take a couple of minutes to explain your history so that everyone can be familiar.
Yeah, thank you, and it's an honor to be joining the board today, so I'm very appreciative. So my background is I've lived in Utah for 26 years now. Prior to that, I lived in Wyoming, and I've worked in the mining industry for majority of my career. I was telling a few folks this morning that, ironically, when I first moved to Salt Lake City, I started off working right across the road with Utah Power in the North Temple office, so it's kind of ironic being back in the same area. But I spent a number of years with Pacific Corp in various roles, and then I joined Rio Tinto, a large mining company, to where when I left Rio Tinto, I was the vice president for health, safety, and environment and communities. I joined Vale, which is another large mining company based out of Brazil. And when I left Vale, I was the chief operating officer for their base metals division globally. So, and currently, I work at the University of Utah. I'm the director for the Health and Safety Center Excellence for Mining, and I also teach a few classes. So again, very appreciative, and thank you.
Welcome to the board. We look forward to your expertise. Okay, we are going to move along now to the informal part of our hearing. The first thing on the agenda is a presentation by FourPoint. And Dana, if you want to handle the introductions.
Yes, good morning. That is the introduction. FourPoint. FourPoint came to us and they wanted to meet with the board, and we thought that the briefing session was the most appropriate way for them to do that with a quorum of the board, and so here they are to introduce themselves.
Good morning. I'm Eric Eichler. I'm the Chief Operating Officer of FourPoint Resources. On behalf of the entire FourPoint team, really appreciate your time here today, and thank you so much for allowing us to make the introduction. Before we go too much further, I do want to introduce my colleagues here. Clint, if you want to.
I'm Clint Cook, a senior landman with FourPoint, and I've been with the FourPoint team for a little over 10 years now.
My name is Scott Osborne. I'm a senior landman. I've been with FourPoint for just under 9 years.
Bryce Caldas. I'm Vice President of Geology, and I've been with FourPoint since 2014.
Great. Well, FourPoint has roots that really go back over 20 years when our founder and CEO, George Solich, built our predecessor company called Cordillera with an opportunistic and technically driven vision. Since that time, we've operated assets spanning from the Bakken in North Dakota to the Anadarko Basin in Oklahoma and North Texas, to the Gulf Coast and the Permian Basins in West Texas. I've been with the company almost 9 years, and although our assets have changed over that time period and the technology has continued to evolve, FourPoint has really always been drawn to Utah and the Uinta Basin specifically for its world-class rocks, unique opportunities, and really constructive governance in the state of Utah. So with our recent acquisition of OVINTIV's assets in the Uinta Basin, we're very excited to finally join the oil and gas community here in Utah. If you're all able to see the presentation, I'll just give a quick overview of the asset that we did acquire from OVINTIV. So this sits in the central basin of the Uinta. We acquired 126,000 net acres with current production right around 37,000 BOE per day, about 80% of that oil. On that position, we currently have about 200 producing horizontal wells. We anticipate, based on future delineation and activity that we anticipate in the basin, to have roughly around 900 future drilling locations. So certainly a lot of growth and potential opportunity here. We currently have one rig operating in the basin with plans to expand that over the next several years. So hopefully with all success, I think we'll be in front of the board here several times and really look forward to cooperation and a constructive effort going forward. With that, we'll move to the next slide here. FourPoint currently has 42 employees. We're based in Denver, Colorado. We have 86 field employees based in Mighton. Really excellent staff in Utah here. Tremendous tenure with OVINTIV and other operators going back to Newfield and a lot of history in the basin. So tremendous experience. Really excited to have that team on board. And I think, with a combination of the technical team we have in Denver as well as the field staff, really look forward to successful operations here in Utah. I'll pass it to Bryce. He'll take the next couple slides here.
Yeah, thanks, Eric. Again, my name is Bryce Caldas, Vice President of Geology. As I mentioned, I've been with FourPoint for just over 10 years. Prior to coming to FourPoint, though, I was working for Newfield in the Uinta Basin on this very asset. So I was part of that initial transition team when we acquired it from Harvest, drilled a lot of the initial vertical delineation wells, and really kicked off our 5K and ultimately 10K drilling campaign in the basin. I had the pleasure of working with the board many times on some of those early respacings, and definitely look forward to working with y'all going forward in the future on a lot of our activities in the basin. As Eric mentioned, we have been in a lot of different basins over the years, or the FourPoint kind of parent, and I think certainly since I've been at FourPoint these past 10 years, we've always had a very keen eye to try to get into the Uinta. It's somewhere I've always truly wanted to get back to. As Eric mentioned, the world-class rock that is there and the opportunities it presents have really driven that desire. Especially in the past 5 or 6 years, we've been fairly active in trying to get in, and now we couldn't be more happy to have landed, especially with our old asset in the basin. So really a tremendous opportunity for us to kind of come home in a sense. So kind of jump into this slide, just to kind of speak to some of the core kind of capacities of FourPoint. We've been around for a while. It's kind of nice every time we do kind of transition from one basin or one asset to the other, we still kind of keep our core competencies and groups together. So we come with a full complement of bench strength to jump into this asset. Of course, we'll be staffing up and adding to each of these categories, but these truly are kind of the tenets that our company kind of is proven upon. First and foremost, kind of our technical approach. We really pride ourselves on bringing an integrated technical approach to really help us delineate the best places to be in the various basins where we operate, and really feel that that's something that drove us to get into the Uinta again with this asset. Operations, we've been active in a lot of basins over the years. As you can see on the slide, we've drilled over 380 horizontal wells over that time, and look forward to drilling a lot more in the Uinta here in the near future. But we've operated as many as 2,000 wells at a time, so we've flexed and changed as the company's grown over the years, and definitely have a lot of capacity in that regard. I will point out too that our current VP of Operations is another former Newfield hand, Matthew Mienka. And he's also pretty excited to be back in this same part of the world, but he brings a lot of expertise from those days with him into this operational capacity here now. Land and business development. We do have a proven track record of great acquisitions over the years, and that speaks to us being able to get into this one now, but also most importantly, as we try to prove up kind of our runway of opportunities here. We have all the full capacity here to really work with the state and all the other partners here to prove up our permits and get our kind of inventory in line. Marketing and midstream, we do have a key presence in our office for that, and always have. That's something that is going to be critical on this asset, as y'all well know. And whether that's historically us just finding a home for barrels or building out full midstream and gathering infrastructure, that's something that we've done in the past and have the capacity to do. And certainly we'll try to lever as much as we can of that experience going forward in the Uinta. And finally, accounting. We try to be a very good financial partner. Definitely pride ourselves on paying our bills on time and being good stewards of for all our partners in this basin. So something we'll continue to really stress going forward. But these truly are kind of the tenets that we kind of pride ourselves on, and what we'll be bringing to work every day in the Uinta. On to this next slide, just quickly touching on ESG. This is something that is a core tenet for us as well, and something that we're committed to going forward out here. we really truly try to be the best environmental steward possible in every area we operate, and we will certainly carry that through into our footprint here in the UNA. We truly want to minimize our impact on everything we do out there, and that's something we've always done and will continue to do and stress going forward. Socially, we've always tried to be very well integrated in all the communities that we operate, and that's something that we're already actively looking to try to do. Historically, in other areas such as the Anadarko, we had a big roundup every year where we'd have working interest owners, mineral interest owners, and surface owners, and even vendors all come together to kind of build that community, and kind of, we hope to try to do things along those lines in our new community out here in the UNA. And then finally, governance. We're excited with our two main partners, both Quantum and Kane Anderson, to really step into this basin and this asset. I can guarantee that we all kind of share the same alignment and vision for this asset and where we want to see it going forward. And ultimately, those two and FourPoint are very committed to ESG and everything we can do out in this part of the world going forward. Kind of with that, that's kind of a lot of the broad strokes on who we are, and I'm very happy to be operating here in the state of Utah, and definitely look forward to any questions y'all might have of us.
Thank you. Back to you. Are you going to?
We'll just open it up for any questions you might have for us, I think.
Okay, well, welcome to Utah. We look forward to seeing you again here. OVINTIV has been a great partner, and we hope to keep up those associations. Board, do you have any questions for these folks?
Just one real general question. Generally, where are those other 900 locations that you're considering as an asset?
So it's a pretty broad position, but basically across multiple benches, we have multiple landing targets and reservoirs that we anticipate drilling. So in 3 dimensions, those locations would be located pretty broadly throughout the field. There are some existing wells that obviously we need to be cognizant of and space away from, but generally speaking, they're distributed kind of across multiple reservoirs in the field there.
So you're looking at some stacked.
Yes, exactly.
Okay, great, thank you.
Who's managing your basin office?
So we have a senior superintendent. His name is Don Bromley. He's been with OVINTIV long time. We had a lot of continuity in the transition there, and he is heading up the field office out of Mighton, Utah.
Great. Do we have any other questions? Well, thank you very much for your presentation. It's good to get to meet you, and we wish you much success here in Utah. Take care.
Thanks.
Back to you, Ms. Dean.
Okay, our next item is a legislative update. The session ended earlier this month, and Natasha Balliff will update us on that.
Good morning, Ms. Bayless.
Good morning. Sorry, I'm switching my computer over. I do have a small presentation for you. Okay, good morning. I'm Natasha Balliff. I'm the Legislative and Planning Coordinator for the division. And today I will be presenting our legislative wrap-up. I know that the majority of you, minus Mr. James, got my email probably 2 or 3 weeks ago after the session ended, but we're going to go over all the bills that have any impact to us, and I'll just get into it. Feel free to stop me anytime if you have questions. So the first one is Energy Education Amendments. This was House Bill 157, and it directs OED to establish the Energy Education and Workforce Development Advisory Group, which is a mouthful. I hope that they come up with an acronym for it or something. But it does include our director as a group participant. So it was one that we were tracking, didn't have any fiscal impact on us. It will require some of our time. We have geologic carbon storage amendments. This was House Bill 352, and it gives the board enforcement authority over Class 6 wells, and it also provides for civil and criminal penalties for violations. This was something that the EPA was asking of us. We didn't have it currently in our statute. We wouldn't be able to get primacy without it. So luckily, Representative Christine Watkins was able to run that for us, and she did a fantastic job. We have environmental legal action amendments. This was House Bill 438, and it modifies the definition of environmental action, and it excludes our coal mining permits from a frivolous lawsuit protection statute. This was something that was put in place 14 years ago and has not been used since then. We got a ruling from OSM, I believe, that said we were at risk of losing our primacy if we didn't get the coal program exempted from that. So luckily we were able to quickly figure it out and get it put in this session. Moving on to brine mining amendments, this was House Bill 478. If you remember last year, we conducted a brine mining study, and this year we took that study and then enacted the Brine Conservation Act. And this grants rulemaking authority. Oh, disconnected for just a second. It grants rulemaking authority to the board, and this one will require rulemaking from the division and the board. We have our mineral surety study. This was Senate Bill 34, and it requires the division to study certain surety issues and then report those findings back to the Natural Resources October interim committee meeting. And I'll quickly run through the list of items that we're supposed to study. So this is one or more forms of surety that should be imposed, the amount of surety that should be imposed, the factors the division and the board should consider in determining the form and the amount of the surety, similar surety requirements made on operators by others with the intent that the surety requirements are coordinated and not duplicated, when sureties should be released, appropriate actions to enforce and collect against an operator, surety requirements in other states, whether insurance products or captive insurance companies should be used, whether a state surety pool should be created in statute, and any other issues that the division finds helpful. There's also a bill regarding federal guidance letter amendments. This was Senate Bill 198. And it requires a state agency to publish certain federal guidance letters on the public website and then send a copy up to the legislature as well. It also establishes standards for the information that should be published on the agency's website, and I believe that should be something that we can easily and seamlessly put into our website. And then finally, we have severance amendments. This was Senate Bill 234, and this addressed our mineral exploration tax credit. It did fix the eligible claimant definition, and then it also unintentionally disqualified all operators from eligibility. So it requires all mines to have, it requires a mine to have all permits, licenses, and approvals be no longer in effect before exploration can begin, for them to claim that tax credit. And that's an impossible task. Impossible task because mining cannot occur without an active permit, and permits don't usually expire unless there was negligence or non-compliance. So the times that there's actually a closed mine permit is very rare. And then the fiscal note misunderstanding was a legislative analyst incorrectly asked a different division for input on the tax credit, and that resulted in a misunderstanding of the credit itself and the potential impact to the severance tax account. So this is something that hopefully we'll have on the schedule we have as a bill next year in the legislative session to correct it. But that's it for the legislative update. If you guys have any questions, I'm happy to answer them.
Board, do you have any questions for Natasha? Mr. Church?
Yes, Natasha.
Yeah.
As you look at all of the different things that have come out of the legislature, is it going to require any manpower increases in the division, or are things going to be able to fall into place?
This one should be pretty easy to put in place. I don't think there's any manpower behind it. The only requirement or big requirement from us will be rulemaking for the Brine Mining Act.
Thank you.
Yeah, of course.
Mr. Moon?
There was a bill requiring partisan equality on boards. Did that one?
Yeah, that did pass.
That did pass.
And it did,
Removed
yeah, it just removed the political requirement for specifically Board of Oil, Gas, and Mining.
I received a couple phone calls on that. I didn't know if they knew I was on a board. I
Interesting.
had some phone calls, and they were encouraging me not to, to
Not
not
to
support
pass that. Huh.
So, but anyway.
Yeah, I've heard that there's some tricky things going on behind the scenes of other boards, and so they just decided to
Yeah.
remove it overall. But
Yeah, I didn't have any strong feelings about it.
We have any other questions? So how does Senate Bill 34 on the sureties, how does that fit into our rulemaking for bonding? Are those two entered?
It's specific to mining,
Yeah.
so it
Gotcha.
doesn't affect the oil
Okay.
program.
yeah,
Okay.
yeah, it'll be for minerals only, and we already have a contractor set up to handle that study. So
Okay.
we'll see where it goes, and then that could potentially lead to rulemaking in the future.
Well, it sounds like they kept you busy.
Yes.
Okay,
Yes.
now we have a rule discussion by Natasha
By me.
as well.
Hi, welcome back. Rule discussion. This one will go pretty quickly. The oh my gosh, I'm sorry. Let me collect my thoughts for a second. The recycling facilities that we were moving the waste component over to Limerick, the waste management and radiation control. Sorry. So that was just finalized. You guys set the effective date at our last board meeting in February. Since then, we have been going over all of our rules based off. Ultimately, it's coming down from the executive order from the governor to look for permit by rule, where people can get approved just by meeting the requirements. And in our review of that, we realized that we missed a section within our R649 rule that should have been removed with last month's rulemaking. So you'll see the reference on the screen, R649-6-2. This is waste crude oil treatment facilities. We already have a section that's addressing this in our new recycling facility rulemaking. So that it's replaced by R649-9-6. And you can read the entire title there. I won't read that one out loud. So we're just asking you guys if we can initiate formal rulemaking just to redact or to repeal that one section, R649-6-2. And then we also have a couple incorrect references that we've noticed throughout the rule, so we'll just go in and do like a quick general cleanup. And I think that we might also be bringing additional rules to you later in another month or two, because we've noticed some inconsistencies.
Does that require a motion from us?
Yes.
So can we have a motion to have Natasha begin
Just to, yeah,
to begin formal
formal
rulemaking?
rulemaking, yep, to repeal
On-
R649-6-2.
Okay, I'll make a motion to direct the division to work on R649-6-2.
Thank you.
Do I have all in favor, please say aye.
Aye.
Any opposed? Please note Greg Galecki is absent today, but it was unanimous by the board members here.
Awesome.
How many rulemaking things do we have coming up in this year? We've got waste, we've got brine.
I think waste will be good. Well, granted, there's going to be these little cleanup ones that we have. Hopefully, Brian can come before you guys this year. I'm not entirely positive that it will.
Okay.
We are working on the oil and gas bonding rule that I believe you guys are going to be hearing from UPA next month. We will have our minerals program, the entire R647 rules coming before you. That was one that we worked with Rich Borden and Greg Galecki on some of the edits. I'm trying to think. Carbon sequestration. We're planning on bringing that to you in a formal matter to request formal rulemaking in May, I believe, is our projected timeline. And then I will also be bringing 5-year rule renewals to you. I think Gordon Moon might be the only one who remembers, but when I first started this position, the programs and these rule renewals were kind of all over the place, and I have been working very hard to get all of the programs on the same schedule. So we don't actually have any rules up for renewal this year, but I am going to bring the entire R649 oil and gas set of rules to you to review, so that finally gets all of them, all the programs on their own schedule. So I'm not going to be bringing like 3 different rules before you. It'll be a solid chunk of here's all the coal rules, here's all the AMR rules. So that should be in the next couple of months.
So let me ask you, the board is still concerned, this is moving on to the bonding rule.
Mm-hmm.
The board is still concerned about how we get notice to the small operators that this bonding rule is in place. And I guess we talked this morning about would it be possible to send a postcard to active operators in the state saying these oil and gas rules are pending, and if they would like to make presentations to see us in April. Is that doable?
I would believe so.
I think so. That was
Yeah,
going to be
something
my
like
next
that.
thing that I was going to talk about, our new postcard system, but I think so.
We're just concerned about the little operators that don't show up with
Yeah.
UPA or some of the other things,
I think
how
we
we
can
can
do
at
that.
least get them notice that something is pending.
Yeah, yeah.
Yes, I think we can do that.
Yeah,
Okay.
we should be able to do that.
And Natasha, does that fall to you?
I'm sure I will be helping out with it. I will probably have to rely on Julianne and Patty because they know how to do the postcards, and then someone in our oil and gas program to get operator
Addresses, but we should have those. And
Yeah.
I don't know why we wouldn't be able to do it.
Yeah.
We
And
should
if you
have
could-
addresses, and we have the postcards. I don't know why we wouldn't be able to do it.
Okay,
Yeah.
if you could work with Paula on any wording or
Okay.
Yeah,
anything
absolutely.
and see if we can get it out as soon as possible. I don't know that we're under any 30-day window or anything that would,
No.
that
Yeah.
we just, as a public service, we're letting them know.
Yeah. Yeah. And I can look into how difficult it would be to switch out the QR code. We could have that link just to our rulemaking website where we have the little comment box open for people to make comments.
Yeah, if you could just, I hate to add additional tasks to you, but if you could get it out as soon as possible
Yeah.
so they have time to
Yeah,
come
absolutely.
to the April meeting.
Yeah, I'll see what we can do.
Thank you.
Of course.
Back to you, Ms. Dean. Let me ask you, at the last meeting during this informal session, we had talked about people being able to submit written comments on the oil and gas bonding rule.
Right.
Have we received any, other than the stuff we have received from Ricky Horenko Browning? Have we received any written comments about
Not that I'm
bonding?
aware of. The website is up and active, but I'm not aware that we've received any comments yet.
Okay.
But I haven't checked. I can check and let you know as soon as this briefing is over, just to make sure.
Yeah, we'd like to hear from anyone who wants to make a presentation at the April meeting.
Okay.
And at the April meeting, we would like to do, it will be an agenda item in April. And we'd like to have oral presentations from anyone who would like to present. I mean, we'd like to hear from as many people as possible with thoughts on how to do this.
Okay.
And if you could coordinate with Paula Ferber, our attorney, we'd like to hold them to maybe 20 minutes. I don't know how long. I know we have a couple people that have expressed interest
Okay.
and would like to make oral presentations. So just to keep in mind, we have that coming up in April.
Okay. We'll do that, and I'll check for comments. I'm not aware that any have come
Okay.
in, but I'll double check to
Yeah, I
see.
think the only one I'm aware of is the comments from the UPA.
Yes, those are the only ones I'm aware of. at
Okay,
this
and
time.
I think the board all has copies of those that we can review also and have ready for the April meeting. So,
Okay.
good deal. Anything else?
Each of you should have a sample of these postcards that we're starting to use for mailings now. These are replacing reams of paper that we were sending out to people. We were sending the entire matter of information out to individual people who have interest in the lease. Now we're able to send these postcards and direct them to our website for information. We don't have an estimate on how much money we're saving yet because we've only done one, and we'd like to get more data before we try to tell you how much money we're saving. But it has saved a lot of time so far. So we just wanted you to be aware that we're now implementing the postcards. We have the new printer in place that uses these, and in a future meeting we'll get you an idea of how much money we're saving after we have a few more data points. And then next month's calendar, for the first time in many months, we don't have any examiner hearings. That'll be nice for our staff. But something we are trying to set up is a board member orientation. I do have a doodle poll out there. I'm waiting for a couple more responses before we can set up a date. Just be aware of that. But we're hoping to get that scheduled, and so that we can get new board member James appropriately trained. Unfortunately, we didn't get it done before today, but we want to get that training done and have the appropriate people that you've asked to be involved in that. I sent that poll out yesterday to the people you asked me to, and we're just waiting for a couple more responses.
Thank you.
That
Appreciate
is
you doing
the end
that.
of the division's presentation today.
And I think actually this works out fine because he was not officially sworn in until today.
Okay.
So doing it in April, I think, is timely.
Okay.
For these new board members.
Yeah.
I think they should be officially sworn in before we do the orientation.
And that makes sense. So we're ready as soon as we know
Okay.
what dates everyone's available. We're just waiting for a couple more responses.
Super. That's great. Thanks, you guys, for all the work you do. I mean, this is very time-consuming. Mr. Moon.
We've had some discussions about having, the same savings that the division is realizing for the operators and the attorneys that represent them. Where are we at on that discussion? Are we able to do it as easily and cleanly?
That's a
for
good
them?
question. I need to follow up with board counsel on that. I know that we had a discussion, but we'll keep that moving.
Okay.
This takes care of the big mailings for the board, does it not? Am I correct? And so
this is findings of facts, but the request, we could do the same thing with the request and then any other follow-ups. I mean, any comment from?
Are you talking about for the petitioners?
Yes.
Mr. McDonald, do you have any thoughts on
That'd be a
this
good
matter?
thing or not?
Mr. McDonald will have a thought, I'm sure. Or two.
Fred McDonald, as you know, I practice quite a bit in front of the board. Mitch, if you want to add anything as well. I'm very concerned from the operator standpoint. The request for agency action has to be served, particularly in a matter like a compulsory pooling matter where a person is directly named and being served and affecting their rights. So I'm not sure it's going to help us with the request for agency action. I think it needs to be served by them. But again, I do appreciate the process that has to go through, and I do believe all the remaining pleadings that get filed, including the exhibits and things like that, the notice is simply done by a card, and if somebody's interested enough, they will go to the website and get the information.
So on a forced pooling, you do have those being forced pooled, and I would completely agree with you on that. But for all of us other mineral interest owners, the hundreds, thousands of others, we don't necessarily need the big stack, the $5 to $10 stack.
Well, the question there is again, and I know the argument, and there's some attorneys that would disagree with me, but my concern has always been the allegations are that the operator has properly voluntarily pooled the interest under a lease. And if an owner doesn't get notice of that action and they feel they're not leased anymore, or that they struck a pooling clause or something like that, they need to be notified of the filing of the request so that they can file a protest as necessary. So that's why we, at least I do, notify everybody in the drilling unit so that they're under notice that the allegation by the operator is they have properly pooled and they're leased, and therefore they don't need to be compulsory pooled.
Okay. Okay. And I would just argue, push back a little bit, that a card like this with a link to the actual request on the website, where the exhibits could be found, et cetera, would be much more beneficial to a leased owner than the full request with all of that. But that's just my opinion.
I understand, but again, the concern is if we don't notify it and it's challenged, and then we're back at it again.
And so what you're saying is this doesn't really qualify as notice?
For the operator, yeah, it may.
Okay.
Because again, unless you're specifically notified, you have to understand what the allegations are that everybody else is being, they have to have the notice of the opportunity to challenge if they don't believe that they're being, the allegation that the voluntarily pooling is enough. I mean, that could be litigated. I mean, I understand your point there that, that should put them enough on notice, but I'm not sure it does.
And I guess it's a difference between experienced people out in the basin who are familiar with this, and then someone in Chicago who might have an interest and not be familiar.
Or the great-great-great-great-grandson of the guy that still owns the record. They don't even know that they own the mineral interest out.
Right.
But if it's a discussion, I'll be happy to have that discussion with division and board council. If they feel that adequate due process is protected by simply getting the card, then we can go with it.
Yeah. Operators would probably appreciate that, but.
Oh, I can definitely tell you that, and so would our staff
and
when
attorneys.
we mail everything out.
Yeah, for sure. Great. Thanks for your comments. Back to Ms. Steen. You have.
The division is done with their presentation.
Thank you so much. Appreciate you filling in for Mr. Thomas. Now we have an opportunity for public comment. Is there anyone in the audience who would like to make a public comment? Ms. Renko, Browning.
Ms. Chairman and the board, thank you. I just wanted to...
Would you introduce yourself?
Yes, sorry. Ricky Renko Browning, president of the Utah Petroleum Association. Just wanted to really briefly follow up on the legislative summary that Natasha provided as well, and highlight two issues on the oil and gas side that I had raised previously, and so wanted to follow up on. On SB 234, which is the mineral exploration tax credit that Natasha walked through. The other thing that bill does on the oil and gas side that's extremely beneficial is it allows a company that has been approved for a high-cost infrastructure tax credit, which can include infrastructure projects, gathering lines, for example, like FourPoint was talking about, or emission reduction projects, which is going to be extremely important in the basin with a number of new rules that have come down, to offset some of those costs directly from severance tax revenue. So in the past, those offsets from a high-cost infrastructure tax credit could only be applied to income tax, and now they can be directly offset from severance tax, which is a pretty significant change and something that I think will be beneficial for the industry. The other bill that I wanted to mention was SB 207 from Senator Winterton, which I believe I raised last month in front of you as a potential. That did pass. What it will do is set out an additional tax on production, 5 cents a barrel for oil and 1/4 cent per MCF on gas, statewide, with the allocation of those funds being collected going back to the county of origin to be used for road projects, particularly focused on paved roads to help support road maintenance needs. It is a 3-year life only. It is supposed to sunset after 3 years, and it preempts a county from any individual county-based similar type fee or exaction, et cetera, so that there isn't a kind of double jeopardy situation with the county and the state both collecting for the same purpose. The implementation of that won't start until 2026 production, and again, it's a 3-year life, so 2026 to 2029. Just to be aware of for the board that is an additional tax that will be calculated and collected in the same way that severance is on the producers. Thank you.
Thank you. Board, do you have any questions for Ms. Browning? Great. Thank you.
Thank you.
Is there anyone else who'd like to make a public statement? We'd love to hear from you. Seeing none, thank you, Ms. Dean. I think we'll take a 10-minute break here before we start the formal part of the meeting. So we'll see you back at 10 o'clock. Thank you. Good morning, ladies and gentlemen. We're going to commence the formal part of our board meeting here with item number 1. Docket number 2025-023, cause number 132-77. In the matter of the request for agency action of OVINTIV USA, Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Alice 13-7, 4-3-18-19-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of all sections 1819, 4 South, 3 West, USM, Duchesne County. This was a hearing examiner matter, and we will move to our hearing examiner for introductions.
Okay. Thank you, Chairman Garrison and members of the board. My name is John Rogers, and I'm an environmental manager with the Division of Oil, Gas.
Mr. Rogers, can I have the presenter introduce himself? Are you going to, and the division?
Okay.
Yeah, appearances.
Yeah.
Fred
Sorry.
McDonald of Counsel with Lear & Lear on behalf of petitioner OVINTIV USA, Inc.
Thank you. And division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
I don't want to skip anyone. Back to you, Mr. Rogers.
Let me make a quick. Our family has mineral interest in these both this the Alice and the Phillip, both of these matters. So I wanted to disclose that, and I would like to participate, but I won't be voting.
Mr. McDonald, do you have any issues with that?
No.
No issues from the division.
Thank you. Mr. Rogers?
Did you introduce yourself?
I'll introduce myself. I'm Assistant Attorney General Gary White, and I represented the hearing examiner in this matter.
Thank you.
Okay.
All right.
I act as a hearing examiner of this proceeding as directed by this board and the matter just described by Chairman Garrison. The proceeding was held with an anchor location in the Department of Natural Resources building in Salt Lake City, Utah on Wednesday, March 19th, 2025. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of OVINTIV from Mr. Peter Burns, a senior land advisor, and Mr. Christopher Wall, a senior reservoir engineer, both from OVINTIV. These declarations were reviewed by me and the division prior to the hearing. The attorneys just introduced and were present today were also present that represented their respective clients at the hearing. Both of OVINTIV's witnesses were accepted by me and the division as expert witnesses in their field of work for this matter. They also presented live testimony electronically in the hearing. The division filed a response and notice of non-opposition to the request for agency action dated March 10th, 2025. Based on the resolution of the previous mentioned objections, at the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those owners that failed to participate timely should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geological conditions present in connection with the drilling of this well. I therefore recommend that the 300% non-consent penalty be imposed as required. OVINTIV has met its burden of proof and otherwise satisfied all legal and requirements to compulsory pool the non-consenting party. For your interest, approximate working interest owners were OVINTIV working interest at 86.83%, non-operating working interest at 9.56%, and compulsory pooled interest at 3.61%. The average weighted fee landowner royalty interest was approximately 19.02%. OVINTIV's counsel, Mr. McDonald, prepared proposed finding of fact and conclusions of law in an order granting the request for agency action. Both the division I reviewed and approved of the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It shall now be ready for the board's review and its execution. I would take any questions at this time if you have.
Board, do you have any questions for Mr. Rogers?
Just a quick question. 3.6 is, well, this is more of a question for the petitioner. 3.6 is a pretty large unlocated interest. Just wanted some explanation of, in general, if there's any explanation why.
Mr. Dale, Mr. Burns is unavailable today, but Mr. Dale is familiar with this. He could answer that question if you'd like. I can add my point is that if you look at it, there was 98 people that were compulsory pooled. And so it adds up a little bit. But Mr. Dale, if you want to add anything to that, please do so.
No, I think that's a fair statement. There were an awful lot of mineral owners within these sections. And as Mr. McDonald pointed out, 96 owners, total unleased or non-participating, or more accurately, non-responsive to this, our action here. I think it's just a matter of it being really carved up and a lot of people not knowing what they own or what this pertains to, and have just remained silent.
Thank you.
I would also add that the whole two sections are entirely fee-owned, so there's no other mineral interest owners in there, so that made the large number also.
Board, do you have any other questions? Mr. McDonald, do you have any further clarification? Division?
Yeah, the division is in concurrence with Mr. Rogers' report and has no additional comment.
Again, Mr. Dale and Mr. Waller here if the board did have any additional questions. I do want to clarify a couple things. With Mr. Moon's caveat this morning, the order needs to have something, a minor revision to reflect that was submitted to indicate that he would be participating but not voting. So I just want to point that out. I don't know, I can make that change and submit it to the council and to the board secretary if you'd like to do that.
Yeah, I think we'll need it clarified.
All right, I'll be happy to do that. I'll do that this afternoon.
All right.
Other than that, again, there was a lot of people here. You talk about the paperwork, and this is where I really appreciate the staff and Mr. Rogers. The paperwork that was filed is probably the size of the Manhattan phone book. So anyways, all the requirements have been satisfied. The company really went out of their way to try and identify all these people and make sure that they're covered on this one. We do believe that all the statutory requirements were made. We agree totally with Mr. Rogers' recommendations, and we ask that the board enter that with that amendment concerning Mr. Moon's statement this morning. And again, particularly thank Mr. Rogers and the IT staff for allowing the virtual participation.
Thank you. Board, do we have a motion to accept this petition?
I move that we approve this request for the hearings examiner's results.
All in favor, please say aye. Any opposed? Please show that it was unanimous. We'll wait for those corrections and then we will execute the order.
Thank you.
Thank you. Moving on to item number 2. This is docket number 2025-024, cause number 132-78. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Phillip 13-7, 4-4-13-24-1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 13 and 24, 4 South, 4 West, USM, Duchesne County. And we have appearance of counsel.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Hearing examiners.
Assistant Attorney General Gary White on behalf of the hearing examiner.
Thank you. Mr. Rogers.
Thank you. Chairman Garrison and members of the board, my name is John Rogers, and I am an environmental manager with the Division of Oil, Gas, and Mining. I act as a hearing examiner in this proceedings as directed by this board for the matter just described by Chairman Garrison. The proceeding was held with an anchor location at Department of Natural Resources Building in Salt Lake City, Utah, on Wednesday, March 19th, 2025. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence on behalf of OVINTIV from Mr. David Dale, manager, Rockies Land, and Mr. Christopher Wall, a senior reservoir engineer, both from OVINTIV. These declarations were reviewed by me and the division prior to the hearing. The attorneys just introduced and present today are also present and represented their clients at the hearing. Both of OVINTIV's witnesses were accepted by me and the division as an expert witness in the field of work for this matter. They also presented live testimony electronically at the hearing. The division filed a responsive notice of non-opposition to the request for agency action on March 10th, 2025. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on behalf of OVINTIV. After reviewing the request for agency action, the sworn declarations and admitted exhibits, and hearing live testimony presented at the hearing, I found and recommended the following. OVINTIV provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pull. Proper notice for the hearing examiner's proceeding was also provided. Those owners that failed to participate timely and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of this well. I therefore recommend that the 300% non-consent penalty be imposed as requested. OVINTIV has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest, approximate working interest owners, OVINTIV working interest 90%, non-operating working interest 7.9%, and compulsory pulled interest 2.1%. Average weighted fee landowner royalty interest was approximately 19.00%. OVINTIV's counsel, Mr. McDonald, prepared proposed finding of facts, conclusion of law, and an order granting the request for agency action. Both the division and I reviewed and approved of the proposed order. I then executed the proposed order and filed it with the board's legal assistant. It should now be ready for your review and execution. I would take any questions at this time.
Thank you. Board, do you have any questions for Mr. Rogers? Okay. Mr. Haynes on the division.
Yeah, thank you. The division's in agreement with Mr. Rogers' report and has no additional comment.
Mr. McDonald, do you have any further comments?
Yeah, just for clarification on this record, Mr. Moon, is this another situation where your family in the same situation? Okay, then we will need to, again, amend the order that was submitted for this one to account for his statement.
Okay.
Otherwise, again, for the board's information, both of these sections are owned entirely in fee. Again, there was a large number. Many of them were the same parties that were in the previous matter as well. With that, again, we thank Mr. Rogers and the staff for their help on this. We believe all the requirements have been satisfied. We agree with Mr. Rogers' conclusions, and we would ask that the board enter the order with that amendment as requested. And we thank again Mr. Rogers and the IT group for allowing the virtual participation.
Thank you. Board, are we ready to make a motion on the amended, I guess, request?
I move that we approve the amended request for agency action as presented by our hearing examiner.
Do I hear a second?
Second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Please note it passes. And Mr. McDonald, if you'll provide the amended order, we'll get it signed.
Thank you.
Thank you. Moving on to item number 3. Docket number 2025-013, cause number 199-09. In the matter of the request for agency action of Mark Tokarski for an order requiring an accounting and payment of proceeds from ARB Energy Utah, LLC. I believe this is a matter that was dealt with by the division. Mr. Haynes?
Yeah, thank you. We're just here today. This matter was filed by Mark Tokarski on December 19th, 2024, in accordance with Utah Code 40-6-9. the board set this matter for the Division for Investigation Negotiation. As part of that investigation, the Division, and I should indicate I'm also here with Brittany Wallace, who is an auditor with the Division. I apologize for that. The Division set forth to investigate Mr. Tokarski's request. The Division mediated that through the parties, and we ended up filing the Division's report on March 12th. I believe you have a copy of that report. It was filed with the board. So we're here today to answer any questions you may have about the situation so that you can proceed.
Board, I don't think this requires a motion on our behalf. I think it's informational, but if you have any further questions for Mr. Haynes.
So for those of us that were delinquent and didn't read that report, would you briefly summarize it?
I will defer to Brittany to let you know the Division's role.
Good morning, Board. My name is Brittany Wallace, and we conducted an investigation, and through mediation, the parties agreed to resolve the matter outside of a formal hearing.
Thank you. Is that clarification, Mr. Moon? You good? Thank you for submitting the report. I believe that fulfills our obligation in this matter, and we thank you for your time. We are now moving on to item number 4. Do you need a minute to get set up? You good? Okay. Docket number 2025-018, cause number 600-07, in the matter of the request for agency action of Uinta Wax Operating, LLC, for an order modifying the board's orders entered in cause number 139-134 and 600-01 to reduce the perpendicular setbacks to 330 feet for horizontal wells, increase the number of authorized long lateral horizontal wells from 17 to up to 36 in the drilling units established for such wells thereunder, and inclusions of sections 13 through 16, 21 through 27, 34 through 36, 3 South, 1 West, USM, Duchesne, and Uinta counties. Appearance of counsel.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Uinta Wax Operating, LLC.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining, and I'm joined by Division experts Peter Pankey and Regina Echo.
Sorry, I'm getting my stuff together here. All right, back to you, Mr. McDonald.
Thank you, Madam Chair. With me today testifying on behalf of Uinta Wax are Ms. Deidre Stoley. Deidre, if you just wave your hand. Thank you. Mr. Robert Horner, who, and Ms. Stoley is the in-house counsel for Uinta Wax. Mr. Horner is the senior geologist of Uinta Wax. And Mr. Taylor Cotton. Taylor, would you please wave your hand? Thank you. The reservoir engineer of Uinta Wax. All of these parties share duties with Uinta Wax Operating, LLC. And I would ask that the Vice Chair swear the witnesses in at this time.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
The resumes of all 3 witnesses were collectively submitted as Exhibit A in this cause. If asked, each will confirm that the information reflected in their respective resume is true and correct. Ms. Stoley will be a fact witness only. Mr. Horner and Mr. Cotton have been previously recognized as experts in geology and reservoir engineering, respectively, by the board. Based upon their resumes and previous recognitions, and presuming the division has no objections, we again ask that they be recognized as experts in those respective disciplines for purposes of this cause.
Division?
No objection.
Board, any objections? So accepted.
Thank you. Also, just to confirm with previous practice that I'll move for admission of all of our exhibits at the end of our presentation in chief.
That'll be fine. Thank you.
Thank you. Madam Chair and members of the board, Uinta Wax is before you today seeking approval of 2 actions. First, to reduce the perpendicular or the east-west horizontal well setbacks from 560 feet to 330 feet. and to increase the authorized number of long lateral horizontal wells from 17 to 30, up to 36 for 7 existing stand-up drilling units within Township 3 South, Range 1 West, USM, which is straddles the county line between Duchesne and Uintah counties. Both actions will require modification of the 139-134 order, which authorized only 17 long lateral horizontal wells per drilling unit and originally established the 560-foot setbacks. That order was modified by a 600-01 order, which simply reduced the heel-toe setbacks to 100 feet. True and correct copies of the 139, 134, and 600-01 orders were collectively submitted as Exhibit B in this cause. As the board is aware, the long lateral horizontal well development in the basin continues to modify based on experience gained by operators. This includes data reflecting that a reduction in the perpendicular setbacks to 330 feet will not adversely affect the correlative rights of adjacent owners. Furthermore, cube development is becoming more the norm, and new members of the Lower Green River Wasatch Space Formation, for example, the Douglas Creek and Garden Gulch, are being tested and developed, necessitating an increase in the number of the authorized wells. Both actions have been previously approved by the board in other areas of the basin, for example, in cause numbers 470-03, 470-07, and 470-12. Today's testimony will provide further support for granting similar relief as to the 7 drilling units at issue. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all working interest owners, including any unleased owners within the 7 drilling units at issue and in the surrounding drilling units, and also to the Bureau of Indian Affairs, the Vernal Field Office of the Bureau of Land Management, which serves as the technical consultant to the BIA, the Ute Tribe, and the Ute Distribution Corporation, due to the tribal and/or allotted minerals ownership throughout the area. The mailings were sent to these parties at their last addresses disclosed by the relevant BIA and county realty records. The record will also reflect that notice was duly published in the Salt Lake Tribune on March 2nd, 2025, and in the Uintah Basin Standard and Vernal Express on March 5th, 2025. On March 10th, 2025, the division timely filed a response to Uintah Wax's request, stating that the division does not oppose the granting of the relief requested, presuming Uintah Wax satisfies its burden of proof at this hearing. As today's testimony will reflect, Uintah Wax will sustain that burden. No other objections or responses were received. With that, I'll commence my examination. Ms. Stoley. Ms. Stoley, would you please state your name and business address for the record?
Deidre Stoley, business address is 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what is your current position with Uintah Wax, and how does it relate to these drilling units at issue?
I'm an in-house counsel for Uintah Wax with land supervision over the areas at issue.
Okay, would you please state for the record the corporate and bonding status of Uintah Wax Operating LLC?
Uintah Wax Operating LLC is a Delaware limited liability company in good standing with principal place of business in Fort Worth, Texas. We're duly authorized to conduct business in the state of Utah, and we're fully bonded with all relevant state of Utah and federal agencies. We are also the designated operator on behalf of Uintah Wax LLC, which is the named lessee for our properties.
All right, I'm going to show you what have been marked as Exhibits C through F for purposes of this hearing. Do you recognize these exhibits?
I do.
Okay, were they prepared by you or Uintah Wax personnel with your review and input?
They all were.
Okay, starting with Exhibit C, would you please explain to the board what this shows?
This is a regional locator map. It shows the areas at issue as outlined in the box in red. They're just south of Roosevelt and southwest of Fort Duchesne, covering areas in both Duchesne and Uintah counties.
Now, turning your attention to Exhibit D, would you please explain what this shows?
So in the box in red, that's our specific drilling units at issue. It shows 7 stand-up, 2-section drilling and spacing units for the Lower Green River and Wasatch production, all located in 3 South, 1 West. These were established under Rules 139, 134 order as modified by 600-01 order. They're specifically comprised sections 13 and 24, 14 and 23, 15 and 22, 16 and 21, 25 and 36, 26 and 35, and 27 and 34. We are also the majority working interest owner in all of these units.
Now, turning your attention to Exhibit E, which is a 4-page exhibit, starting with the first page, would you please explain what that shows?
This shows all of the existing producing wells in the relevant 7 units.
All right, and the second page?
Second page shows specifically all of the Castle Peak production wells.
The third page?
Third page would be the Uteland Butte.
And finally, the fourth page.
Fourth page shows the wells producing from the Wasatch.
And what's the intention behind these exhibits to reflect for the board?
Reflects for the board that we as a company believe that only allowing 17 long lateral horizontals in each unit are going to leave resources unrecovered, and my coworkers, Mr. Cotton and Mr. Warner, will talk specifically about that.
All right, now turning your attention to Exhibit F, would you please explain what this shows for the board?
F shows that everything outlined in purple is the notification area. We notified all working interest owners and those unleased owners. The owners within the red box, those were notified due to the fact they're all cost bearing, which they will be affected by potential larger development with more wells. Those also included in the purple were given notice because of the requested reduction in the perpendicular setback.
All right, I'm going to ask you to refer to the certificates and supplemental certificates of service, which were pleadings already on file prepared by my office. Do you have those in front of you?
I do.
And that lists the number of parties and their addresses. Do you recognize who they are, and how were their names and addresses derived?
So this entire list shows all of the owners that we notified, unleased and working interests, including the Ute Tribe, the UDC, and federal agencies with jurisdiction over the Indian oil and gas. These addresses were compiled from our internal records, including title opinions, and we also contracted a land service to do a search of the BIA and Duchesne and Uinta County records.
So bottom line, those are the parties that were notified as reflected on Exhibit F, correct?
Correct.
All right, thank you. Madam Chair, that concludes my examination of Ms. Stoley.
Division?
No questions for this witness.
Board, do you have any questions for this witness? Mr. Walker?
Yeah, on this Exhibit F, sections 25, 26, and 35 and 36 has some very tight spacing. Will that be explained by you or by Mr. Cotton?
Yes, it will.
Okay.
They will be able to talk about the technical specifics.
Thank you.
Yeah, and again, just they're stacked, and that'll be explained.
Do you have a breakdown of federal fee and state, how much percentage-wise within this project? Do you have all three? Do you have federal, state, and fee leases?
I do not have them in front of me at the time, but I would be more than happy to supplement that information.
Yeah, I usually like to see a breakdown of what's federal fee and state.
Okay, well,
just
that's fine. We can certainly provide that information.
Thank you. Please proceed.
One quick question.
Oh, one question.
So how was this area determined? For example, do you operate the wells to the east of the red line here, section 18, 19, 30, and 31? And what is the spacing there, and why were those excluded from this?
We are not the operator to the east. That's why they were not included in that. To the east side, we are the operator, but those wells were already included in another spacing hearing that also, to my understanding, increases the density and reduces the setbacks. So the remaining areas in red that we operate, we're just trying to match those areas. To the west side is where we are not the operator, so we did not request to space that.
Okay, that makes sense. Thank you.
Board, do you have any further questions? Please proceed.
Thank you. With that, I'll commence my examination. Mr. Horner, would you please state your name and business address for the record?
My name is Robbie Horner. Our business address is 6000 Western Plates, Suite 1000, Fort Worth, Texas, 76107.
And what is your current position with Uinta Wax, and how does it relate to these drilling units?
I'm a senior geologist with Uinta Wax, and I am in charge and overseeing all the geology of these units.
All right, I'm going to show you what have been marked as exhibits G through J. Do you recognize these exhibits?
Yes, sir.
Were they prepared by you or Uinta Wax personnel with your review and input?
Yes, sir.
Starting with exhibit G, would you please explain to the board what its significance is to today's hearing?
Yes, this is a type log that's been used to define the lower Green River and Wasatch throughout the basin, including the 139-134 order.
Now, turning your attention to exhibit H, please explain what this exhibit shows and its significance.
Yes, on the west side, we've got a locator map. There's a cross-section that is outlined in blue that goes from west to east, representing wells that are across the position. And towards the center right is that cross-section. And on the left side, you'll see our breakout of what we determine the upper Green River, lower Green River, and Wasatch. And on the right side, you will see on the bottom right that we're currently focused on development in the Castle Peak through Wasatch. And we believe that there's strong potential and look forward to developing the upper portions of the geology in this unit in the lower Green River.
Does this also reflect uniformity in these various formations across the area?
Yes.
All right, thank you. Now turning your attention to exhibit I, would you please explain what this shows and its significance?
Yes, on the left is a locator map with 3 stars indicating 3 projects in which we had obtained microseismic data, and that has allowed us to figure out our fracture half length as well as our orientation, which is 252 feet with an average and an average orientation of north 85 west.
All right, and finally on exhibit J, what does this show?
Similarly, in continuance of the last slide, the purple is showing the microseismic stress orientation, and the blue shows a dipole-sonic stress direction, but all in they average out to north 85 west.
And again, the significance of these go to the issue of the offsetting reduction in the perpendicular setback, which Mr. Cotton will address. Is that correct?
Yes.
All right. Is it your expert opinion then that the uniformity of the lower Green River Wasatch members throughout the area make long lateral horizontal wells attractive, particularly as to undeveloped shallower zones?
Yes.
Madam Chair, that concludes my examination of Mr. Horner.
Thank you. Division.
No questions for this witness.
Board, do you have questions?
Yeah,
Mr. Walker?
Yeah, could we go back to I just for a second? I just want to look at the range that you had. Okay, so you had as little as 199 and as high as 343. Okay, thank you.
Mr. Church?
Yes, Mr. Horner, on your microseismic, do you see any variation in the stress vertically in the stratigraphic section, or is the stress direction equal from the top down through the bottom of the section?
I believe that is covered in part by Mr. Cotton's slide, but I do not recall without having reviewed the reports for those 3 wells.
Okay, I'm assuming that you're planning on the stress not changing to any great degree vertically at all, that it affects the whole stratigraphic section.
Correct.
Do we have any other questions? Seeing none, please proceed.
Thank you. With that, I'll commence my examination. Mr. Cotton. Mr. Cotton, would you please state your name and business address for the record?
Yes, my name is Taylor Cotton, and our business address is 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what's your current position with Uinta Wax, and how does it relate to these drilling units?
I'm the reservoir engineer for the area at issue in 3 South 1 West.
All right, turning your attention to what have been marked as exhibits K through P. Do you recognize these exhibits?
I do.
And were they prepared by you, or you went to wax personnel with your review and input?
They were.
Turning your attention to exhibit K, would you please explain what this shows and its significance to today's hearing?
So exhibit K shows the current east-west spacing at 560 feet setbacks. And then pulling in Robbie's average fracture orientation and the average fracture half length, it reflects significant areas of resources that could be recovered with reduced perpendicular setback without adversely affecting correlative rights.
Now turning your attention to exhibit L, please explain what this shows.
This shows the proposed new east-west setback spacing of 330 feet and still reflects, even with that proposed new spacing, that there is 79 feet of buffer to the adjacent lands.
Now turning to exhibit M, would you please explain what this shows?
Yeah, this depicts the anticipated long lateral horizontal well development in each member of the Lower Green River and Wasatch in a wine rack formation. Please note 16 wells are planned for the Garden Gulch and Douglas Creek. 12 wells are planned for the Long Point, Lime, and Sand within the Castle Peak. And notice also the fewer wells are planned for the Uteland Butte and Wasatch formations. Recent developments in the Uinta Basin suggest these additional members, the shallower members, may result in more prolific production throughout long lateral horizontal well development. We're asking for 36 wells, but you'll note that the depiction shows 37 wells because there are existing Uteland Butte drilling boundary unit wells. If you refer back to Exhibit E, it shows in the Uteland Butte where we've drilled those drilling unit boundary wells.
Okay, turning now to exhibit N. Please explain what this shows.
This exhibit shows where the wells are located, where the PVT samples were derived for the drainage calculation.
And that's exhibit O. And if you'd go through this for the board.
Sure. This exhibit shows the previously referenced Hale and Evers drainage calculation, which has previously been utilized and approved in several board hearings. It shows that 330-foot setbacks will result in no drainage of adjacent east-west lands even after 40 years. That's column AF that I'm referring to there on the far right.
Okay, finally turning to exhibit P, please explain what this shows.
So this is a well economics slide showing that the well economics clearly favor drilling additional wells and the requested 330-foot east-west setbacks. I'd like to note that the calculations reflect a conservative estimate due to the lack of development in the shallower target formations, but each additional lateral would result in about $940,000 of additional collected severance tax, which in turn from 19 additional horizontals would be about $17.9 million in additional severance tax.
All right, is it your expert opinion then that the reduction of the perpendicular setback to 330 feet and the drilling of up to 36 wells in each drilling unit are necessary to recover additional resources that would otherwise be left in the ground?
Yes.
Is it also your expert opinion that these requested relief will allow the greatest recovery of natural resources with associated greater economic benefit and without adverse impact on adjacent correlative rights?
Yes.
All right, Madam Chair, that concludes my examination. Mr. Cotton?
Thank you. Division, do you have questions?
No questions, thank you.
Board, do you have questions? Mr. Moon?
So the wells, you do have some drilling unit, drilling boundary, whatever they're called, section line wells. Because prior you had 560 offset setbacks. Is that correct?
Mm-hmm. That's correct.
So just explain, why you went from that to the 330 setbacks and no drilling unit boundary wells. Just kind of the why.
Well, I think we would still have the drilling unit boundary wells, but the reason for going from the 560 to the 330 is because, and you can go back to exhibit I believe it's exhibit, the development model. Yeah, that one. You can kind of see how they, as we move up stratigraphically, we begin to offset. And that means you're moving a little bit east-west, a little bit east-west, depending on which direction you're going. So in the UB, which is the originally planned wells, those were kind of uniform with drilling boundary unit wells and then 1320 off each of that. So, 4.5-ish in each unit. But we don't like stacking the wells. So as we offset them, we move closer and closer where we were going to cross over that 560 and need to reduce that back to 330, if that makes sense.
I think so. So you see this as just a more efficient way, but you are saying that you will have drilling unit boundary wells, because this request doesn't ask for that, or does it?
We've been doing that in the Uteland Butte, so I believe we had that, but maybe, I don't know if that's target formation specific. Maybe Fred, do you know?
It's not in this particular request, and part of it, the reason is because of the different operatorship on the western portion that Ms. Stoley talked about. So, but on the eastern side, either they may have it or presumably they will come back and ask for it as necessary.
Okay. So you still feel like you can get a drilling unit boundary well in a 330 offset setback? There's room there. It on the one slide, it did show like the 70 or 80 feet. But maybe, these are theoretical questions for down the road. You're going to drill the main area first, but just curious.
Yeah, I think especially on the eastern side and then in between we operate everything in that kind of L shape. If we operate on both sides, I think we would definitely ask if we don't have permission to drilling unit boundary well, so that we could fully access all the resource. And then on the western side, I think that would be something we'd have to talk to. I think FourPoint is the operator over there. But that would be one-off cases generally.
Thank you.
Board, do you have any further questions? Mr. Walker?
Yes, could we go back to Exhibit L just for a minute here? Because I think that clarifies that for me. Oh, okay, there we go. Okay, so this setback here, this would be the setback that would be applicable on the western side where you are not the operator there, but wouldn't necessarily be the setback that you would enforce on the eastern side or within the drilling unit?
No, the request is for the setbacks on both the east and the west.
Oh, is it? Okay. Okay, so you will protect. Okay, got it. All right. That satisfied what I needed to do. And I applaud the wine rack stacking thing. That's highly effective, and I know it takes a lot of science and engineering to do that, so thank you.
Board, do you have any further questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. With that concludes our presentation in chief. At this time, I would move for admission of exhibits A through P inclusive.
So accepted. Oh, I'm sorry. Division, do you have any objections?
No objection. You read my mind.
Board. Back to you, Mr. McDonald.
Thank you. With that, I'll reserve my closing argument or closing statement until after the divisions make their statement.
Do you have any closing comments, Division?
Just briefly, the division has carefully reviewed the request for agency action, the exhibits, and having heard the testimony and explanations today, has no objection to granting this request.
Thank you. Board, do you have any closing thoughts? Are we ready to make a motion? Mr. Walker?
Yeah, make a motion that we approve the request for agency action as requested.
I'll second that.
All in favor, please say aye.
Aye.
Any opposed? Please note it has been accepted. Would you please prepare the order, Mr.
Certainly.
McDonald?
Thank you, board members, for your time and attention.
Thank you. Mr. McDonald, do you know when the official closing date was for OVINTIV and FourPoint? When did they take over? Okay. Okay. Thank you.
Just a question also, Fred, on that. So the OVINTIV matters we heard earlier today, those will be asking for a change of operatorship to FourPoint.
It'll be applicable to it. Again, the reason that OVINTIV did it was because they were the operator through to essentially January. And so they get the majority of the revenue that is attributable to the non-consenting owners, the 300% risk assessment. And then from that point, there'll be an accounting adjustment between OVINTIV and FourPoint. And to the extent there's additional development, although those two wells, if you recall, were both one-offs because they're north-south, and now the drilling units have been changed east-west.
Yeah.
So.
Okay, thanks.
Thank you for your patience. I think I'm ready.
No problem. No problem. Moving on to docket number 5, or item number 5. Docket number 2025-019, cause number 132-75, in the matter of the request for agency action of FourPoint Resources, LLC, for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Armstrong 13-7, 4-3-18-16-7HX well, identified herein in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 16 through 18, 4 South, 3 West, USM. This matter has been withdrawn. I'm sorry.
That's okay. I handled that one and withdrew it. So I'm happy to answer any questions, if any, but it will be refiled at some point.
Okay, sounds good.
Thank you.
Moving on to docket item number 6. Docket number 2025-021, cause number 470-16, in the matter of the request for agency action of Vaquero Uinta, LLC, for an order amending the board's orders in cause numbers 270-02, 270-04, and 470-02 to establish 4 overlapping 640-acre DSUs, establishing 1 special 960 DSU and 3 overlapping 1280-acre WDSUs for the production of oil, gas, and associated hydrocarbons from the Eocene Middle, Lower Green River, and Wasatch formations underlying the Three Rivers area, comprised of sections 34 through 36 in 7 South, 20 East, Salt Lake Meridian, and sections 2, 3, and 10 North Half in Township 8 South, 20 East, SLM, all in Uinta County. Mr. Mayo.
Thank you, Madam Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner, Vaquero Uinta. With me today are Michael Anderson, Russ Griffin, and Levi Anderson.
Division appearance.
Yeah, Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and I'm joined today by Peter Pankey and Colton Goodridge of the division.
Thank you. Back to you, Mr. Mayo.
Thank you, Madam Chair. Again, Mitch Mayo, appearing on behalf of the petitioner Vaquero Uinta LLC. With us today are Mike Anderson, the Director of Land for Vaquero, Venator Resources, the parent company of Vaquero, Mr. Russ Griffin, the petroleum geologist for Venator and Vaquero, and Mr. Levi Anderson, the senior engineering advisor for the company. Could we please have the court reporter, or the vice chair, swear in the witnesses at this time?
Sure. Please raise your right hands. Okay. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Thanks, guys. Thank you for that. The resumes of these three witnesses have been submitted collectively as petitioners Exhibit 1 in this cause. If asked by the board, they would confirm the content and accuracy in those resumes. All three witnesses today we would like to have testify as experts in their respective causes. Mr. Anderson has testified before this board before, but is not. Mr. Michael Anderson has testified before this board in prior causes, but has not been qualified as an expert, so I'll attempt to do that in his testimony. Mr. Russ Griffin has testified and been recognized as an expert before the board in prior causes, most recently in May of 2020 in cause number 470-02. In light of Mr. Griffin's experience and recognition in prior causes and based on presumed stipulation from the division, I'd like to move for him to be recognized as an expert now.
Division, do you have any comments?
Mr. Griffin.
Just for Mr. Griffin? Yeah, no objection to that.
Okay.
Board, do you have any questions? So accepted.
Thank you. With our other Mr. Anderson, Mr. Levi Anderson, he has not testified before this board at all. So I'll be qualifying both of the Andersons as witnesses during their testimony, or attempting to, I should say. Also, with board's permission, presumed stipulation of counsel, I'll be moving for admission of our exhibits at the end of our case in chief.
Thank you.
We are here today, as Madam Chair said in reading the caption, to request essentially the transition, something the board doesn't see regularly anymore, the transition of an operator from vertical development only to a hybrid of vertical and horizontal development. What Vaquero is requesting specifically is sectional drilling units, with the exception of a 960-acre unit that we'll address. But essentially sectional drilling units for short lateral horizontal development with the accompanying section line wells, lease line wells, drilling unit boundary wells, as they're referred to here. Excuse me. The relief requested here today is something the board has done regularly over the years, but as I said, less so recently, as more and more operators are already established in drilling horizontal wells. Most of the spacing the board encounters these days is changes to already existing horizontal development plans. But this, as I said, is the transition from vertical to horizontal development plans. The establishment of the drilling units requested here today requires a little bit of modification of existing spacing orders. Those orders were entered in cause numbers 27002, 27004, and 47002. I may refer to those as the current orders. Collectively, these current orders establish 40-acre drilling units, including some special lease line drilling units, the equivalent of what we are seeing in drilling unit boundary well units. These units were all established solely for vertical and directional drilling, and it's key to note the existing wells and units are subject to current production setbacks of 460 feet laterally, in this instance east-west, and 330 feet heel-toe, north-south. Those are the same setbacks that are being requested for these additional units, so there will be no change in the setbacks, or I guess continued protections to the production of offset drilling units and owners. The board has jurisdiction over this cause pursuant to Utah Code 40-6-5 and 40-6-6. Notice was provided as required under Utah law to all interested parties, production interest owners within the unit, and all unleased and working interest owners outside of the unit. In addition, notice was published in the Salt Lake Tribune on March 2nd and in the Uinta Basin Standard and Vernal Express on March 5th of 2025. The division filed a response in this cause, noting that it does not oppose the board, that it, quote, does not oppose the board modifying the current orders in order to establish the requested drilling unit scheme, end quote, pending, of course, a full and satisfactory presentation of evidence and testimony here today. And we believe that will be presented. In addition to the division's response, I'd like to note that we did receive one written objection in this cause from a Mr. Larry Maddox. Mr. Maddox was here earlier today. I spoke with him. I believe he is gone and is watching / participating remotely at this point in time. But Mr. Maddox's sister, I believe, her name is Beth McCody. She's here today, and I'm imagining would like to essentially participate or express their objections more fully when the board feels appropriate.
Thank you.
Yep. I told Ms. McCody that the typical practice is I will present my case in chief, the division will respond, and then typically the board will ask for participation from anyone in the audience. If the board prefers a different procedure, please let us know, and we're happy to change
That'll be fine.
Okay. To be clear, Mr. Maddox's concern is with potential issues. Mr. Maddox owns an interest off the spaced areas, so he's in the buffer area, if you will, and his concern, rightfully so, is whether this will change or impact the production from his wells. Mr. Anderson, as he'll testify about, reached out and spoke with Mr. Maddox about his objection. I also reached out and tried to talk with him, was unable to, but I have talked with him here today. Because the setbacks don't change, we're of the position that there will be no impact from historical development, and we've communicated that to Mr. Maddox, but we'll address that as the testimony goes on. In addition to the parties here, the division and Mr. Maddox, who have responded and participated, no other parties have timely responded or sought to participate here today. We must then infer their approval, tacit as it may be, to the request here before you. With that, I'll begin my examination of Mr. Michael Anderson. Mr. Anderson, will you begin by stating your name and business address for the record?
Michael Anderson, 3 Greenway Plaza, Suite 1360, Houston, Texas, 77046.
Okay. And what is your current position with Vaquero?
I am the Director of Land and Regulatory for Vaquero Uinta. In the relationship between Venator Resources, they are the managing company for Vaquero Uinta.
Okay. As Director of Land and Regulatory for Vaquero, do you exercise a supervisory role over the land records that would be associated with the development that we'll be discussing here today?
I am.
Okay. Can you please briefly provide the corporate and bonding status for Vaquero?
Yeah, Vaquero Uinta is a Delaware LLC in good standing. Like I mentioned before, Venator Resources is the payroll accounting office, the managing member for Vaquero Uinta, so that's the relationship between Venator and Vaquero Uinta. We do operate in the state of Utah, licensed, bonded, all the necessary things.
Okay, so fully and appropriately bonded for the board's sake.
That's correct.
Okay, and you have testified before this board before, is that right?
I have in cause 470-02.
Okay, and before we begin your testimony, I'd like you to testify as an expert witness in petroleum land management issues here today. Can you, as part of that, I need to give you a chance to explain your qualifications and the division and board a chance to ask you questions to confirm. Can you walk the board through kind of high level your resume and your qualifications as they relate to being a land expert?
Yes, I got my degree in finance at West Texas A&M. I got my MBA or Master's of Science at Oklahoma City University. I started in this industry as a contract landman. in various basins, the Powder River Basin, the Scoop Stack, or Anadarko Basin in Oklahoma. Moved into a role in-house managing family minerals at Canyon Exploration. Everything from leasing to debt creations. Transitioned and moved from Canyon Exploration to Chaparral Energy, where I was a district landman and EUR landman. Both of those roles involved settling surface ownership or surface use agreements, creating drilling and spacing units, proposing wells, doing force poolings in Oklahoma. From Chaparral to Meadows Oil and Gas, I went back to being a contract landman. That was due to a bankruptcy with Chaparral Energy. Was a short stint at Meadows Oil and Gas as a contract landman, also doing Oklahoma Corporation Commission prep work, testimony. From Meadows Oil and Gas to Trinity Operating, I was a senior landman managing 4 rigs. Again, doing the same thing, deck prep, division order title opinions, unit prep at the OCC level, everything from surface use agreements to how things are paid and disputes as it relates to division order matters. From Trinity to Jones Energy, same role, senior landman, worked creating units, cleaning up drilling and spacing units that were drilled prior to, mentoring younger landman, and then from Jones to Venator, which was previously Bainbridge Uinta, which they owned and operated the lands that we are discussing herein. So Bainbridge was senior landman, again, doing all the regulatory permitting actions, as well as testifying before the board in cause 470-02, handling surface owner disputes, mineral owner disputes, and ultimately everything from a surface use agreement to how things are paid, and then ultimately managing decks as well.
So pretty broad experience in education, but the last almost decade has been focused in the Uinta Basin.
That is correct.
Okay. With that, it's probably appropriate to open the board or division to any questioning of voir dire of Mr. Anderson's expertise.
Board, do you have questions for this witness?
Yeah, the division has just a couple questions. You indicated that you have your resume, a Master of Science in Energy Management from Oklahoma City University. I'm not familiar with that degree. Could you just give a little background on that?
Yeah, so it was about 2010, Oklahoma City University created, since Oklahoma City is a big hub for oil and gas development, they created a Masters of Science, which is, they had 2 programs, one of which was in energy management, and one of which was in Masters of Science in energy legal studies. So both of which were geared towards, obviously the legal side was geared towards contract prep, contract structure, midstream type agreements. I decided to go to the energy management route, which was the Masters of Science. That program basically brought in executives at the C-suite level in Oklahoma City to come in, and classes really geared towards accounting, your business analytics, your kind of waterfall structures, your basic MBA type programs to make you kind of a well-rounded energy professional.
Okay. And subsequent to you obtaining your education, do you have any additional certifications or licensings related to petroleum land management?
I do not. I am slated to get my certified, my CPL with AAPL at the end of this year.
Okay. And you already indicated, I believe, around a decade in the Uinta Basin in a landman role. Could you just explain to me what your current day-to-day operations are right now. Do you manage other landmen, or what do you do with Vaquero?
Yeah, so Vaquero UNA is a very small company, so I do have a land tech in California that I manage. My day-to-day is your basic permitting of pipelines on sites with BLM, federal, state officials, anything from pre-unit prep for drilling wells, everything from back-end deck and how everything's paid based on the spacing, obviously testimony here, and creating horizontal or modifying spacing, really everything from negotiating a surface use agreement to on-sites to permitting in the basin for bigger type, tank consolidation projects, et cetera.
Okay, thank you. The division has no further questions, but we're satisfied to recognize this witness as an expert.
Board, do you have any questions about this witness?
Yeah, can I see the second page of the resume again, please, for a second? Okay. All right, so is it fair to say that you've spent about 25 or 15 years virtually full-time doing landman work?
That is correct, sir.
Okay, thank you.
Seeing no other questions, he is accepted.
Awesome. Thank you. As an expert in petroleum land management, to clarify for the record, Mr. Anderson, it's appropriate now to show you what have been filed as Exhibits 3 through 8 in this cause. Do you recognize these exhibits?
I do.
And were they prepared by you or someone in Vaquero personnel or contractors under your direction or supervision?
That is correct.
Okay. Starting with Exhibit 3, can you orient the board as to where your position is and kind of relate it to the Central Basin, which they're used to seeing?
Yeah, absolutely. So what this slide shows, left side, you'll see the state of Utah. Upper right-hand corner on the left slide, you will see the UNA Basin. In that blue box, you will see kind of where we're situated in UNA County. If you go over to the right-hand slide, on here, you will see the red outline, which is the Three Rivers Field. Where we are situated is we have the Ouray Wildlife Refuge to our east, off the red boundary lines, and to our west, we have UNOWAX in the Salt Lake Meridian line that runs southeast to northwest, and then to our north, we have Pelican Lake, right there where the cursor's at.
Okay. And Exhibit 4, can you talk through kind of the, the existing spacings in the area and whether horizontal wells have been utilized out here at all?
Yeah, correct. So on this slide, left side, pink, you will see horizontal spacing that was done at cause 470-15. To our north, you have some additional horizontal spacing that was done. And then as you move left to right, Ouray Park 2, Brennan Bottom, those are federal units that were created that have horizontal component or spacing to them. And as you move south from northeast to southeast, some additional federal units. And then in the middle there, kind of between the pink and the yellow dashed lines, you will see the Three Rivers Field that is operated by Vaquero UNA.
Okay. So essentially there's a couple board orders to the east and a couple to the north addressing and authorizing horizontal development.
That is correct.
And in addition, there's some federal units on the north and to the east where state rules have been suspended, but horizontal wells are allowed.
That is correct.
So it wouldn't be a stretch to say that you're more or less surrounded by authorized horizontal development.
That is correct.
Okay. Exhibit 5. Can you talk through, and we'll actually address Exhibits 5 and 6, so help me go through these as makes sense, but can you talk to the board about current spacing and what you're requesting?
Yeah, so currently, Exhibit 5, you will see on the right side the previous cause numbers that are would be to a component of our subject lands. What you see there is the 460 east-west, 330 north-south. Those green dots are going to be vertical wells on 40-acre spacing. And in some instances, I believe it's 270-04, 270-02, those modified current spacings in some instances to 20 acres.
That's right. So current spacing allows for, as you just said, 460-foot lateral setbacks, essentially between vertical and directional wells. The requested spacing the board's aware of asks for horizontal development. Can you walk them through this slide and show them how the horizontal development fits in with both the existing vertical development and any allowed vertical development in the future?
Correct, yeah. So this slide right here shows a horizontal on a section basis. What you see there in blue running north-south is a depicted horizontal well, and then the green dots are an existing vertical well. What you will see is if you're moving from north to south, you will see that we are 460 off of an existing vertical with an additional 200 feet to where that horizontal would be, so 660. And as you move south, if there would be a special unit or a well that was drilled on a 20-acre spacing, you will see the setbacks that we would adhere to if the board approved our spacing, that we would stay 330 feet off of that existing vertical or 660 away from. I would note that we do not have in these subject lands a well that is depicted on the south side of that section.
So let me see if I can back up and unpack some of this. If we look at this last slide, Exhibit 5, there were a couple orders, right? The 270-02 established 40-acre units with 20-acre density. So they were payable on 40 acres, but it allowed some additional units. The 270-04, as you were mentioning, established these lease line units, the drilling unit, boundary unit equivalents for vertical development, and those essentially allowed for additional wells to be drilled in this area here. Is that right?
That is correct.
So if you look at this requested spacing, we've got a vertical well, presumably authorized on under the 270-02 order, a vertical well also presumably authorized under the 270-02, but then we've got this one here, which is one of those, quote, special lease line units that was authorized in the 270-04 order. Is that accurate?
That is correct.
And I think you just testified, and this is important for the board to hear, that this special lease line unit, none of those have been drilled in the subject lands to date.
That is correct.
And this is just because those existing spacing orders are going to continue in the future. There's a potential someone will drill a special lease line unit, including Vaquero. And in that situation, the board should be comfortable with the setbacks being authorized for the vertical and horizontal development?
That is correct.
Okay. So this well doesn't exist, but it can.
That is correct.
Okay. Moving on to exhibits 7 and 8, and maybe this will help explain. Can you walk the board through what units Vaquero is requesting here?
Yeah, so we are requesting, if you're starting from the northeast corner and working to the northwest, and then down to the southwest to the southeast, we are requesting section 36, 35, and 34. If you move south of that, those three sections are in 7 South 20 East. If you move south, that's going to be section 3, 7 South 20 East, and then section 2, 7 South 20 East. And then right below section 3 in that 960 unit is the north half of section 10.
Okay. So all of these are sectional units except for this one. Can you talk about why this is requested to be 960?
That is correct. So we do not own in the north half or the south half of 10. That is BLM acreage under the O-Ray Wildlife Refuge. Okay. We do not have a lease. That is why we would request just the north half of section 10, because that's what we do have a lease with the BLM.
Okay. And it's my understanding that no one has a lease for the Wildlife Refuge. Can you talk just briefly about that to the extent you're comfortable?
That is correct. There are several stipulations that date back to the 60s in which the BLM severed the surface to the refuge and put some resource management plans in place that allowed no drilling or leasing within the refuge boundaries. That is why you see a gap to our kind of south and east of the yellow.
And does that include directional and horizontal drilling under the refuge? Just
That
for
is
board's education?
That is correct.
Okay. So essentially, those lands, surface and minerals, are off limits to development, as Vaquero understands it.
That is correct.
Okay. Is it fair to say then you included the north half of Section 10 in this unit simply so it wouldn't be left out of horizontal development?
That is correct.
Okay. Thank you for that. Moving on to the next slide. Gosh, fat fingers here. There we go. Can you explain to the board the additional units that you're requesting?
Yeah, what you see there in blue between 36, 35, and then the east half of 34 and the west half of 35, as well as the east half of 3, west half of 2, you see that request for special drilling unit boundary wells. Those are wells in which we own leases on both sides, and to maximize recovery, prevent waste, that it's beneficial that those get added.
Okay. And just to note, the board will notice a difference between these two slides. Presumably the north half of 10 is included in horizontal development here. It's excluded from development here. Is that likely a consideration of fairness between the two units?
That is correct.
Can you talk through that at all, or any other thoughts on that you need the board to be aware of?
Yeah, given that we do not own the lease to the east of the north half of 10, we just excluded it because we do not own or have the rights to drill or produce from there.
Okay. So one last question, I guess, or one last topic I want to talk about before I move on from your testimony is notice provided. You don't have an exhibit, as they did in the prior cause, outlining the notice, but I'd like to talk through it with you. Can you please talk about who was noticed and how you came up with that list of names?
Yeah, I went and pulled all of our internal revenue decks for these said sections, as well as the sections outside of the halo, but inside the red area. So anything that we have well production on, so that would be to the west of 34, to the west of 3, and to the west of 10. We pulled those revenue decks and included them pursuant to the notice provision. We named them, and then in addition to naming who was within those stated sections that are depicted there in yellow, I did a search of surrounding leasehold through Uintah County records, anybody to the right share in production, so that they were noticed adequately.
Okay. And as you mentioned, this area down here, broadly speaking, is let's just say federally owned and unleased.
That is correct.
Okay. Did you notify the agencies responsible for managing these areas?
That is correct.
Okay. There was one objection filed in this cause, Mr. Larry Maddox. Are you aware of the objection? Have you read it?
Yes, read it and did reach out to Mr. Maddox.
Okay. To the extent you're comfortable, can you briefly kind of tell the board, whether you think his objection was resolved or kind of what you talked about?
Yeah. So, but prior to reaching out to Mr. Maddox, did read his objection, did go through with reviewing the internal revenue decks that we have, and did notice that Mr. Maddox was located, his minerals and interests were located in Section 4, so directly west of Section 3. Had probably about a 45-minute call with Mr. Maddox, informed him that, he was notified because of the capturing the additional kind of halo, if you would, for notice, and that, and kind of walked him through what we're doing. as it relates to, adding concurrent horizontal spacing in the subject lands. Let him know that his interest was outside of the subject lands as it relates to the sections in yellow, and then just answer some additional questions that he had.
In addition to Mr. Maddox, did you receive any contact or feedback or response or opposition from any of the other 150 approximately people that you notified, including the agencies?
I did not.
Okay. With that, last question. In your expert opinion, and in consideration of the exhibits 3 through 8 that are here on file today, do you believe that the request the board is considering approval of is the best plan to protect correlative rights, maximize resource recovery, and prevent waste?
I do.
Okay. With that, I have no further questions for Mr. Michael Anderson.
Division.
Yes, thank you. Just staying on this slide right here on Exhibit 8, Mr. Anderson, are you aware who owns or who operates in the lands north of 34 and 35?
Yeah, that is going to be all Finley Resources.
Finley Resources?
Yes, and then the lands to the west of the yellow, those are the Carol Uinta lands. If you see the blue shaded areas there in section 33, those little kind of checkerboard looking, and then as well as the parcel there to the south, those are also Finley Resources. And then you kind of see the keyhole there, which is going to be section 9.
Yep.
That is also Finley Resources as well.
Okay. And was Finley part of, was one of the parties that was noticed of this request?
That is correct.
Okay, great. The other question I have too, if we could go to, slide 5 is fine. Exhibit 5, sorry.
This one?
Yeah. So my understanding is, there is 20 acre density allowed under these orders. Are there any quarter sections that have 2 wells in them?
There are.
Okay.
The bulk of those are going to be in the west portion of our lands there that are not highlighted in yellow. That's where the bulk of the prior 20-acre development was located.
Okay, thank you. Yeah, thank you. No further questions.
Board, Mr. Moon.
Why not 2-mile horizontals versus 2 1-mile horizontals?
I think our geologist and reservoir guy can address that a little bit more clearly. I know, given our position from a land perspective, 1 mile made more sense for us, and just kind of given the unique shape of our acreage position. If we had call it 4 sections stacked together, that would make more sense. But given the condensedness and kind of unique shape, we felt 1 mile was adequate for our development and our size.
Okay, so more of a land question versus a geology driven.
And we'll correct. That's correct, Mr. Moon.
Okay.
Yes, could we go back to Exhibit 6 for a minute? Can you explain, there's a comment down there, no perfs. Does that mean on the horizontal well you wouldn't be perforating near the vertical well, or the vertical well you wouldn't be perforating near the horizontal well, or just nobody's going to perf in there?
Answer that easier because I prepared the language in request. But yes, the setbacks are no producing interval setbacks closer than 330 feet to an existing vertical well.
Could you turn on your mic?
I turned it off so I wouldn't breathe so heavily in the microphone, so thank you. There's a requirement in the request that there be no perforations in the horizontal well bore within 330 feet of an existing well producing. In this instance, there aren't any of those existing lease line unit wells. However, those still exist and can be employed. So it's possible that Vaquero or a successor in interest drills one of those special lease line units. This just clarifies that if one of those is drilled, any horizontal well will have to maintain at least 330 feet on either side. That is,
So it's no perfs on the horizontal well?
Short answer is yes.
Okay, so the vertical well can perforate in that interval, or probably has been perforated in that interval?
If it exists, that's right.
Okay, good. Exhibit 7, again, okay, so you're retaining the 330 north-south setback and the 460 east-west setback, except for the setback, or except for the lease lines.
Mm-hmm.
Okay. And I guess I don't understand the no development of section 10, or the north half of section 10. Are you not going to drill your horizontal wells to that lease line, or are you just going to stop at the section line?
So section 7 shows that we would drill a 1.5 mile lateral.
Exhibit 7.
Or sorry, exhibit 7. We would drill a 1.5 mile lateral covering section 3 in the north half of 10.
Okay.
That is just showing the 960 unit in 7, and then if you go to 8, it shows where we would be creating that special drilling unit boundary well between sections 2 and 3, 34 and 35, and 35 and 36. So just kind of distinguishing that those special drilling unit boundary wells would not get into 10 because of the lease that we don't own in section, I believe, 8.
Okay. So,
or 11, sorry.
Okay. Maybe this is too early to ask, but is it then, are you going to have all your surface locations in section 3 and drilled to section 10, or is it the other way around? Or do you know yet?
We don't know that yet. I know that I can speak to the fact that at Vaquero UNO, we tried to utilize a lot of our existing infrastructure, which mitigates any additional surface impact. We try to be really development savvy and use what we already have in place because of the synergies there and the cost savings.
Mm-hmm.
And I will note, as Mr. Anderson testified, pretty much everything south of that red line is a hard stop for surface developments of any kind. So my guess is they'll operationally look to the north to drill down south, to answer your question.
Okay, thank you. That's all my questions.
Seeing no other questions?
Thank you. With that, I'm done with my examination of Michael Anderson. If you'll take a seat and be ready to be called back if there's more questions. Next witness is Mr. Russ Griffin. Mr. Griffin, will you please state your name and business address for the record?
My name is Russell Allen Griffin. Our business address is 3 Greenway Plaza, Suite 1360, Houston, Texas, zip code 77046.
Okay. And what is your current position with Vaquero?
I am a petroleum geologist with Vaquero Uinta and with the parent company, Venator Resources.
Okay. Based on earlier stipulation from Division Counsel, I'd like to remind everyone that Mr. Griffin is recognized as an expert in geology in this cause. I'm going to show you, Mr. Griffin, similar to what I did with Mike Anderson, exhibits 9 through 14 on file in this cause. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or someone under your direction or supervision?
Yes, they were.
Okay. Let's jump right in. I'll let you talk largely. Exhibit 9, help the board understand how the structure impacts the request here.
You bet. This is a structure map on the top of the Uteland Butte marker in the Uinta Basin. And it shows the relative position of the Three Rivers field in reference to the other major developments in the basin. Just to our southwest is the Greater Monument Butte field with Scout and OVINTIV in those neighborhoods. And so we are slightly down dip from that development. And to our east, the Wansis Valley Redwash fields, which also produce out of the Green River Formation, we're slightly down dip from those. If you look directly to the west in the bluish area there in the middle of the map, that is the area of predominant horizontal development in the Central Basin at this time.
Okay. Exhibits 10 and 11, I'll probably have you talk at the same time. Walk the board through the horizontal stress that you're seeing.
Yes, these two slides are companion slides, one of a regional view of the major principal stress in the area. The second one is more localized to the Three Rivers field. And this is data compiled from a variety of sources, including a substantial number of prior exhibits to the board, and so they're all compiled in one place, so we can see the nice regional trend there. The key importance of understanding the stress is that we want horizontal wells to be perpendicular, or as perpendicular as possible to the principal stress, as that helps utilize the natural and the induced fractures in the formation as a conduit to the horizontal well to maximize recovery.
Okay. And what are those stresses? And I'm sure we'll talk about them more directly, but kind of generally speaking.
Generally speaking, in this area, it would be an azimuth of about 285 degrees, 15 degrees north of a due east-west.
Okay. Exhibit 12.
This type well is the type well from the Three Rivers field, same type well used in prior causes, and shows the commingled interval, which was also approved in cause 470-02, from the mahogany benchmarker down to about 800 feet into the upper Wasatch. As we look at the transition from vertical to horizontal, we've designated a group of potential horizontal wells across this interval. Primarily, these will be, again, set back from existing vertical wells following the currently stipulated spacing. And we will also look at those intervals that have the higher oil in place in order to maximize recovery and maximize also our economic return.
Okay. And you identified several productive zones. Do you have any sense, based on your current vertical development, where Vaquero will focus? Or is
we will focus in the lower Green River in our initial development plan, which will be from the Garden Gulch or slightly above the Garden Gulch down into the Castle Peak intervals of the lower Green River.
Exhibit 13.
Exhibit 13 is an east to west cross section through section 2 as shown in the inset map in the lower right hand portion of the map, A to A prime. These wells are all spaced at 1,320 feet apart. So the intermediate distance between those would be 660 feet. And these green dots that are shown are essentially the wine rack representation of potential horizontal wells, splitting the difference between the vertical wells in the field. I show a number of potential benches here, and again, our focus will be in a Castle Peak member in the lower Green River.
So these black dots essentially represent the authorized locations under the current orders for vertical well development.
Yes, those are existing vertical wells.
And those have to be 1,320 feet essentially apart from one another?
They don't have to be 1,360 feet apart. They have to be 660 feet from any existing well.
Okay.
So our request satisfies both the offset east to west and honors the current spacing as approved.
Okay. And these green, you said, are the horizontal locations essentially?
Yeah, wine rack,
yep. Okay.
Wine rack representation of horizontal wells.
And last, before I let you move on, this Three Rivers petrophysics, can you tell the board about the oil in place and kind of what you've uncovered?
So we commissioned a third-party petrophysicist to do an analysis on the wells in the area to help us understand oil in place, porosity, permeability, rock mechanics, that whole variety of components that go into developing a petroleum system model. With this data, the main takeaways that we used in calculating the oil in place, which will be covered in the subsequent slide, We have a effective porosity of 7% with a 30% water saturation. And the thickness, if we go from the Garden Gulch, remember, top of the Garden Gulch to the top of the Wasatch is about a 1,700-foot interval. Within that interval, we are calculating 300-foot plus of good rock that exceeds the 1 to 2 to 3% porosity cutoff. So, when you look at the whole stack, you look at those 1%, 2%, we exclude that from the volumetrics, and the average porosity of everything above that comes in about 7%. Using that in the standard oil in place calculation, we find about 94,500 barrels per acre within that interval.
Okay. That's perfect. Finally, in your expert opinion, do the slides that you've discussed here today, 9 through 14, do they support the request?
Yes, they do.
Okay. With that, I have nothing further for Mr. Griffin, pending division or board questioning.
Division, do you have questions?
No, the division has no questions for this witness.
Board? Mr. Church?
Yes, Mr. Griffin, is this yellow wax or?
It's black wax. Yeah, we're not as thermally mature, and we're up closer to the edge of the basin. So our oil is more similar to what you would see in the Red Wash-Wansett Valley fields or in those southern extents of the Monument Butte field.
And no overpressuring in this?
No, we're right on the edge of the overpressure cell. If you draw that map, I didn't include that map, but it essentially comes right up onto our northern boundary, and the field itself is normally pressured.
Thank you.
Do we have
Yeah, can we go back to the exhibit with the wine? Okay, go back to that.
This one. Yep.
Yeah. Okay, so we're looking like vertically about 200 feet between these, and then 330 laterally.
So they're
or thereabouts.
Between each vertical well will be 1,320 feet. Splitting the difference of 1,320 would be 660. The prior cause, 470-02, says we have to have a 460 setback. So if I take two vertical wells, do the 460 setbacks, that leaves me a 400-foot corridor north to south in between the existing vertical wells.
Okay, all right, great. Now, are these green dots are the horizontal wells?
That's correct.
Okay, so you're still, as you're doing your wine rack, the scale isn't?
No, these aren't our scale.
Yeah, so you're still, though, between 5,000 and 4,700 feet, you're still pulling 200 feet from one to the other.
And to clarify specifically, the request asks for approval of the standard request, essentially no closer than 330 feet laterally, unless they're separated by at least 100 feet in true vertical distance. And then there's no setback laterally. But based on development plans, it looks like there will be a significant.
They'll still be trying to get that 330. Okay, great. Thank you.
Do we have any other questions? Okay, please proceed.
Thank you, Madam Chair. Last witness, sit down, I'll grab you. Our second, Mr. Anderson, this is Levi Anderson. But I'll allow him to say that. Mr. Anderson, will you please state your name and business address for the record?
My name is Levi Anderson, 3 Greenway Plaza, Suite 1360, Houston, Texas, zip code 77046.
Okay. And what is your job responsibilities generally, and your job title with Vaquero?
I'm the Senior Engineering Advisor for Venator Resources, the parent company of Vaquero Uinta, LLC. Day-to-day, my responsibilities are managing our company-wide reserves, daily production operations, supporting rigs and the engineers, as well as all drilling engineering responsibilities.
Okay. Since we'll be trying to qualify you as an expert today, I've got to ask you to walk through your resume, if you will. Briefly hit on, the division and board will ask you follow-up as they see necessary, but briefly hit on your education, your relevant experience generally, and as it relates to the Uinta Basin or similar basins.
I have bachelor's degrees in both petroleum engineering and finance from the University of Wyoming. Over a decade experience, multiple companies, multiple different oil fields across several states. Generate production cost forecasts for project development, as well as our internal capital budgets. Evaluate and develop economic forecasts for potential acquisitions, as well as perform technical assessment of our reservoirs, identifying opportunities for increased recovery, working with third-party auditors to audit our reserves, as well as banks where topical on the valuations of our assets.
Okay. And how long would you say, how much of that time has been spent in basins similar to the Uinta Basin?
Heavily focused on the Uinta Basin ever since we acquired the asset in 2021. That's been our focus, and majority of my time in the last 4 years has been on the Uinta Basin assets.
Okay. No further questions from me, but the board and division to voir dire.
Division, do you have questions for this witness?
No, we don't have any additional questions for this witness.
Board, do you have any questions?
Yeah, can I see the second page again, please? Thank you very much.
You're welcome.
Do we have any objections? He's accepted.
Thank you. And Mr. Anderson, now that that's out of the way, I'm going to show you, if I can, what's been filed as petitioners exhibits 15, 16, and 17 in this cause. Do you recognize those three exhibits?
Yes.
And
Yes.
Thank you. And were they prepared by you or someone under your direction or supervision?
Yes.
Okay. Turning to 15 and 16, kind of generally, I know there's a lot of information here, but really just a couple nuggets you want to get out. Can you tell the board what about 15 and 16 you think is important?
On this first one, Exhibit 15, this is a type curve of the vertical wells the field's been developed on. There on the right, oil volumes in green, water in blue, gas in red. In the boxes on the left are some generalized economics. Recovery of the oil, about 82,000 barrels of oil on vertical wells, about $1.5 million CapEx investment.
Okay.
Same layout on this. This is the recovery expected production on a horizontal 1 mile well. You can see the production expected there in the same color scheme, oil and green. Higher, about double capital investment, but that higher recovery with the horizontal well, about 156,000 barrels of oil. Similar, but most important thing, positive economic return.
Okay. And they've got a higher, they start higher. If you flip through them quickly, can you talk about that and where that's reflected or what that means to you?
Several things. Main thing is just larger contact with the reservoir. Vertical wells in general only have about 5 to 6 frac stages, single plane of frac. With a 1 mile vertical well, anywhere from 18, 25 frac stages, a full mile contacting the reservoir, plus all those, just more surface area, more contact with the reservoir, allowing more inflow.
Part of the reason you're asking for horizontal wells here.
Yes.
Okay. So given the horizontal and vertical well economics, can you talk about and kind of tie in what Mr. Griffin testified to about the estimated oil in place and what you think this request, if approved, will lead to?
Yes. So trying to fit a lot of information on this slide. Highlighted in yellow matches the slides that Michael and Russ have shown of the areas that we're requesting the spacing. The black short lines and dots are the vertical wells. You can see drilled from existing pads, 2, 3, 4 wells from one pad. The green lines are proposed horizontals for just reference. There in the top left of the table, like Russ mentioned, we have about 2,000 feet of gross pay, 308 feet roughly of net productive pay. That with the porosity and the other volumetrics, about 330 million original barrels of oil in place. To date, the vertical well development has recovered almost 3.5 million, about a 1%. Expected ultimate recovery over the life of the vertical wells would only be a little over 4 million, about 1.3% recovery. Going down to the development, 51 wells, as stated there, about 82,000 barrels each. Ultimately across the areas, 76 horizontal wells, each at about 156,000 barrels of oil. That would result in an overall total EUR of 17 million barrels, about 4 from the verticals, an additional almost 13 million from the horizontals. So that's a additional 3.5% recovery factor from the approval of this, allowing the horizontals.
Okay, and that's actually maybe a clarification or a point just to note for the board. You know, what we've got here is you show here, as you just testified, the current historical recovery from all these black vertical and directional wells is about 1%. You anticipate, or your modeling anticipates, about 1.3% if the vertical wells allowed currently are fully developed.
Yes.
Okay. Down here, you mentioned that the total EUR is about 17 million barrels. Can you talk through this 3.5% and what you think the ultimate recovery is actually, the clarification that we need to make here?
Yep. Yeah, a lot of information on that. Could have made that clear. Ultimate recovery with both verticals and horizontals would be about 4.8%. So 1.3 from the verticals alone, with the additional 3.5% from the horizontals, for a total recovery of almost 5%, maximizing the resource recovery.
So would it be fair to say if this number was 4.8 instead of 3.5, it would be completely accurate with what you're estimating?
Yes.
Okay.
For total combined, yes.
Madam Chair, we're happy to submit an updated exhibit reflecting that to the extent the board's concerned with that, but given that it's modeling and has been clarified in the record, I don't know that it's necessary.
I think to be accurate, we'd like a revised exhibit.
Happy to do that. Anything else, Mr. Anderson, you'd like to point out about this development and how it supports the request, or have we said it all?
Yeah, everything's been said.
Okay. With that, I have no further questions for Mr. Levi Anderson pending the division and board's questioning.
Division, do you have questions for this witness?
Yeah, thank you. Could we just go back to Exhibit 16? I just have a question. So has Vaquero drilled and completed a horizontal in the basin or in this area? What is the current status of horizontal wells?
We've not drilled a horizontal in the basin. We've drilled horizontals, multiple horizontals in California, and in my prior employment, drilled horizontals also in the state of California across multiple fields.
Okay. Because I'm just looking, drilling expenses estimated $3 million. I'm assuming that's per well, an estimate. That just seems lower than what we typically see, but I'm just curious, where does that estimate come from, that number?
So tying back to the question that Mr. Moon had asked earlier, with shallower formation, Central Basin about 10,000 feet, we're closer to 5,000 to 6,000 feet, actually able to utilize smaller rigs, part of why only going for 1 mile instead of 2 miles. The competitiveness and cost of big rigs has significantly been inflated, so that plus other things of having shallower wells, less pressure, are a big factor in that lower than typical 20,000 foot, 2 mile deep wells.
All right, thank you. Yeah, no further questions.
Board, do you have questions? Mr. Church. Oh, sorry.
Yes, Mr. Anderson. So on Exhibit 17, it shows the closest horizontal wells to where you're at are about 3 miles to the west. Have they been producing very long, or do you have that information to help you?
Off the top of my head, all those horizontals were drilled around 2017, and they have been producing since then.
Okay, and their production is similar to what you expect then?
Yes, those 3 wells have a wide range of production, but the middle average is what our expectations are.
Okay, and should we approve this, at what point in time would Vaquero start a horizontal program out here, just in general?
We're actively working and planning and prepared with permit approval to drill this summer.
Okay, thank you.
Mr. Moon, did you have questions?
So your heel toe setbacks, I see here you're requesting 330. 1 mile horizontal, that's cutting quite a bit off. Is it just you're not comfortable going with the 100 foot, which is fairly standard now, especially where your stress orientation is pretty much east-west? Just give me your thoughts on that.
Me or the witness? Sorry.
The witness.
This is following in line with what has been approved in the field and what we have conclusive data on based on the other hearings. That 100-foot setback I do agree with and is believable. Primary on this, since we're starting off first horizontals in this field, was sticking with what has already been accepted and approved with the data that we have.
Okay, so perhaps after you drill one or two, you can get some more data and come back and shorten those up and make them more economic. Do you think you'd get pushback on your south side there where there's no leases? Have you had anything come back from them on what you're doing here? Any?
Just the one protest that we've mentioned is
not from BLM though at all.
No.
Okay. Yeah, because I kind of doubt they would push back against 100-foot, but you never know.
It's likely Finley to the north that might have more concerns. But
what are their? Do they have horizontal spacing around you here, Finley?
That's Finley to the west, right?
I wonder if they're.
There's
the three horizontals to the west of us are Finley, and then just barely off the screen under Pelican Lake, Finley has two horizontal wells to our north.
Okay. What are their setbacks on those? Do you know?
I believe they're the same. 330.
Are they 330?
460.
Okay.
Yep.
Okay. Okay, and then your offset setbacks are
460 to the east-west, 330 to the north-south.
Okay. Okay.
Mr. Walker, did you have a question?
Yeah, I just had one on Exhibit 17. Okay, so ultimately you're going to drill 76 horizontals, and I see 19 green lines there. Are those going to be your wine rack type of arrangement on those?
Yes.
Does each of those green lines represent 4 wells? Okay.
Just, trying to model 3D wine rack to 2D.
Too much stuff. Okay, got it. Thank you.
Do we have any further questions? Back to you, Mr. Mayo.
With that, I'm done with the 3 witnesses, and it's probably appropriate to move for admission of exhibits at this point in time. So I'll do that, just moving for admission of exhibits 1 through 17 on file in this cause, including what will be submitted as corrected Exhibit 17 to address the recovery factor percentage.
So admitted.
Is that a motion that requires a vote, or?
I was going to say, let's go to, do you have any objections?
Yeah, no objections to admitting those exhibits.
Board, do you have any objections to admitting these exhibits?
No.
Okay.
So accepted.
Thank you, Madam Chair. With that, I'll withhold any final comments till after the division's case in chief.
Okay, division.
Yeah, thank you. As we indicated in our response, we've reviewed the request for agency action presented by Vaquero as well as the exhibits. And after listening to the testimony that was presented here today, the division has no opposition to this request being made by Vaquero. We have not addressed the objection that was filed by Mr. Maddox because we are frankly unaware of the specifics of where the objection lays. If there's any further comment on that objection and you would like the division to respond to that, we're happy to after any comments on that matter.
I think we'd like to hear from your witness in the audience now before the board asks questions.
Happy to. I think they mean you, Beth. Is that what you meant, Madam?
Yes.
Okay, thank you.
So from what, is this on? Oh, I'm Beth McCody. I'm Larry Maddox's sister. I also signed that petition that he submitted. Anyhow, from what I understand in listening and watching all of this, we're outside of what they're talking about anyway. Our interest is not in that, it's not in the yellow. So why we were sent the notice to be here is beyond me if we're not part of what they're talking about. Does that make sense?
Yep.
Yeah, where are their lands located? Mitch?
I believe, based on Mike Anderson's testimony, they're located in Section 4, which is this section here. I'm not sure exactly where, but they are essentially just west of the lands under request here.
So you don't have any objection on the yellow outline?
No, it looks
land.
awesome and exciting.
All right.
You know, it's like,
Good.
dang.
Well, that's good news.
Yeah, no.
Okay.
Yeah, so you would have just been noticed because you're an adjacent landowner, so that
Yes.
you could be
Yeah.
aware and question whether they're getting too close. But with a 460 offsetting setback, so they're only going to be 460 from the section line, and then you're going to be another. I don't know how close you are to that section line, but
660 at least.
yeah,
So that
you're,
was the concern. We were worried that
yeah, you're along.
whatever they're doing could encroach
Yeah.
on what we've
Yeah.
got going, you know?
No, yeah, whatever, like you say, whatever they're doing here is going to be encouraging for whoever owns your. I guess you're in Findlay, least of Findlay.
Right.
Hopefully they'll be, doing more drilling there because it's pretty much drilled up as far as 40-acre vertical drilling. It looks like, but the fact they can go back in and do horizontal wells and produce more oil.
That'd be awesome.
It's just to point out that, like they testified, there's only getting about 1% of the oil out of the ground right now.
Oh.
And then these horizontal wells will get another 3 or 4%. And then in 10 or 20 years, they'll go back and get 2 or 3 more percent, maybe, figure out how. But anyway, it's good what they're doing. So
Yes, thank you.
And so your concerns have been answered, is that correct?
Yes.
Great. Thank you for coming.
Thank you.
Appreciate it. Board, do you have any questions? Do we need to deliberate, or are we ready to make a decision? Okay, do I have a motion?
So I move that we approve this request for agency action.
Been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Hearing none, the order passes. Mr. Mayo, if you would prepare the order.
I will, and I'd like to make one quick comment, not to delay anyone's lunch, but I really appreciate Ms. McCody coming here today.
Yes.
I get calls all the time from people who are confused about the stuff we send out into the universe and want to know how it impacts them. And I talk to, probably 20 to 40 people each time we file one. I always encourage them to come and show up and participate, express any concerns they have, and rarely, as the board's aware, do they take us up on it. So I like to acknowledge anyone who does take the time out of their day to come and participate in this process, because it's really valuable to what we do.
Well, if you'd quit being so good at your explanation and taking care of their concerns, they would come.
I'll try my hardest.
So good.
We appreciate hearing from the public and knowing that we're addressing any concerns they might have. So, we welcome any participation from people who need further clarification.
Agreed.
Thank you.
Thank you.
I believe that concludes this matter. I think it's right after 12. I think we're going to break for lunch. Mr. Chicken, are you okay with that?
Actually, that's fine, because I need to confer with Mr. Hayes.
Okay. If we take, do we need more than a half hour, do you think? 12:35 or so? 12:35. We will reconvene at 12:35. With that, we are off the record.
One.
For just 1 second here, and we will convene the next matter. All right. We are moving on to item number 7, docket number 2025-022, cause number 470-17, in the matter of the request for agency action of Robert L. Bayless, producer, LLC, for an order authorizing drilling and production of the proposed Harding State 11-32D-6-20 well and establishing a special drilling unit for the commingled production of oil, gas, and associated hydrocarbons from the Green River and Wasatch formations, comprised of parts of Section 32, 6 South, 20 East, SLM, Uinta County, and finally, compulsory pooling the interest of Lyle R. Harding in said special drilling unit and declaring him as a non-consenting owner in said well. This matter was continued to the April board meeting, and then subsequently to that continuance, the petitioner filed a motion to dismiss. And so at this point, the motion to dismiss was granted on March 20, 2025, and I think the matter has been dispatched. So now we are moving on to item number 8, which is also the last item of the day. This is docket number 2025-025, cause number 134-02. In the matter of the request for agency action of WEM Operating LLC for an order authorizing the flaring of gas in excess of the amounts allowed under Utah Administrative Code Rule R 649-3-20 from the Black Buck 4-4-30-26-1H well with a surface location in the southwest-northwest of Section 32, 4 South, 4 West, USM. The Bongo 4-4-31-35-7H well with a surface location in the southwest-northwest of Section 32, 4 South, 4 West, USM. And the Collins 4-3-19-21-1H well with a surface location in the northeast-northeast of Section 25, 4 South, 4 West, USM. The Gemsbach well with a surface location in the southwest-northwest of Section 32, 4 South, 4 West, USM. The Lee 4-4-24-23-1H well with a surface location in the northeast-northeast, Section 25, 4 South, 4 West, USM, and the Nilgai well, 4-4-29-28-1H well, with a surface location in the southwest-northwest, Section 32, 4 South, 4 West, USM, all in Duchesne County, Utah. That's quite a header. Please proceed, Mr. Chicken.
Thank you, Madam Chair. Some housekeeping items before we get into our witnesses. When filed, the request for agency action sought a exception or variance from the flaring rule, which allows 1,800 MCF per well per month venting or flaring of gas. Our RAA shows that $2,500 MCF per well per month, and requested an extension through May 15th of 2025. I've conferred with counsel for the board and counsel for the division regarding orally amending our RAA here today, and I'll give you the background for that very, very briefly. For why we need to amend this and what our understanding is, and what we've discussed with counsel for the division, who did file a response in this matter. The response essentially saying assuming we provide the appropriate levels of evidence at hearing that they did not object. But that response was filed based on our RAA. Although WEM did a good job of estimating the volumes from these wells, and the reason we're here is that, the wells ultimately outperformed those estimates by quite a lot. And out of the 11 wells in this area, WEM does have 5 of those wells currently connected to adequate gas takeaway. So this was not something that they knew about beforehand. And I wanted to make that clear. WEM is currently and has been for several months now exploring every option, and you will hear more about this from our witnesses today. Expansion of the gathering system through WEM's affiliate Rewater, expansion of an existing Scout Energy connection system, expansion of the Berry Petroleum connection, creation of a new Williams connection, and creation of a new FourPoint connection. So the point is that the takeaway capacity and the issues that are coming with that, the volumes and the gas composition, which seem to be changing almost on a daily basis. So they've got, WEM is getting daily updates on how things are going, and this, like I said, has to do with volume, gas composition, NEPA, right-of-way acquisition issues. But we are working with the aforementioned companies and other ones, both operators and midstream. We are in the southern and western boundaries of the Uinta Basin, and essentially kind of pushing that and exploring, the outer edges of that basin. And this obviously makes these gas takeaway issues all the more difficult because midstream companies aren't real willing to run pipe out to these type of areas before there's it's been proven. I think we've been able to prove some of that area up, but somewhat to our chagrin, just because of we have to solve this gas takeaway problem. And as you'll hear more from the witnesses as well, some of these other entities, other operators, are now just getting their horizontal programs going, like a Vaquero or something like that, like similar to Vaquero. And so their systems that had been using horizontal well gas from companies like WEM are now starting to be reserved for the Berries, the Scouts of the world, so that they can have takeaway for their own gas. So it's a complex problem, and we're doing everything we can to resolve it so that we're not flaring gas and we are instead selling that gas. And you will hear more about this from our witnesses today. And so based on all of this, collectively, the amendment today is we are amending in 3 different ways, and as we've discussed with counsel for the division and some of the folks from the division, the amendment would be to 33,440 MCF per well per month, which is a large increase, but necessary. The extension to go through May 28th rather than May 15th, and the reason for that is very simply May 28th is the next board hearing, and we believe that this will give us enough time to continue to work on these projects, but also to have coverage for our flaring so that we're not in a situation where the board is getting requests to approve an emergency order between the 15th and the 28th, and that helps the board with administrative efficiency. And lastly, the extension would be subject to WEM personnel having an administrative level hearing in April, just prior to the board's hearing in April, to provide an update on any changes, are we flaring more gas, are we flaring less gas, and where our gas takeaway projects and plans are at. And so what this essentially means would be what we are asking for today is an extension and an authority to flare 33,440 MCF per well per month through May 28th, subject to an update in the directly in the middle of that 2-month period. And the division and its counsel can comment further on our discussions regarding that. But I think with that, that's just my preliminary stuff. So if anybody has questions right now before we get into witnesses and that kind of thing, I'm happy to answer any questions.
She was just reminding we before we get going, we need to do appearance of counsel.
Yes, we do.
You're so eager to get going.
Brent Chicken, Steptoe and Johnson PLLC for WEM Operating LLC.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and I'm also joined for this matter by Megan Crocker, who is our Engineering and Geoscience Manager, and Bart Kettle, who is Deputy Director of the division.
Thank you. Mr. Walker has a disclosure before we get started.
Yeah, thank you very much. I just want to make a disclosure that my recently deceased mother-in-law had a 0.07 acre working interest in what WEM is called the watermelon patch. I don't know if this is part of the watermelon patch, yes, but since she is recently deceased, my wife will inherit half of that. So I think that has nothing to do with flaring, since we're not talking about section lines or anything like that, but I just want to disclose that. I still intend to participate and vote unless somebody objects.
No objection from WEM.
No objection from the division either.
Thank you. Now, let me just verify. Division, you have no problem with an oral amendment?
Yeah, we're aware that Mr. Chicken was going to make the oral amendment. So, you know, in the interest of the need for what they are proposing, yeah, we have no objection to the oral amendment being made.
And our board counsel, you're okay with doing an oral amendment? Okay, I think we're on board. Please
Okay.
proceed, Mr. Chicken.
Can I ask a question?
Oh, I'm sorry, yes.
So
Mr. Church.
we're talking a specific number of wells. You say 5 of the 11 are already hooked up?
Correct.
And
So
this is only going to apply to 6 wells, is that correct?
yes, only the 6 wells in the caption that were read by Madam Chair a minute ago. It's just those 6 wells for this RAA, yes.
Any further questions before we proceed? Please go ahead.
My witnesses today are, and I'll bring up their resumes. Mr. Larry R. Williams, who is sitting to my left, Vice President of Land. He has testified before the board before. And our second witness is Dustin Treek, Chief Operating Officer. He has also testified before the board before, and specifically as an expert in petroleum engineering and reservoir management. Would you like to swear those witnesses in?
Yeah, could we swear them both in at this
Absolutely.
time?
Okay. Please raise your right hands. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Yes.
Thank you.
Thank you.
Mr. Williams, I know you've testified before the board before, but if you could just give them, for the benefit of our newer board members, a brief history, educational background, work history, to form the basis for your testimony today.
All right. So I started many years ago. My education, I have a PLM degree from the University of Colorado, back when Colorado had a PLM degree program. After I finished that degree, I went on to law school. I have finished law school at University of Denver, whereas after that I came here to Utah. I'm admitted to the bar. I am a bar member. Practice oil and gas law, mostly transactional. For many years as an independent landman / attorney. Finally spent a couple of years in-house as land manager and corporate counsel at Flying J Oil and Gas in their exploration department when that asset was sold in 2011. I went out as an independent attorney. again for a few years. Went back in-house with a company called Summit Operating. Worked with them for almost 10 years as their land manager and corporate counsel. Spent a little bit of time in the geothermal world, about 6 months, and then was recruited over to WEM here almost a year ago. So that's a quick history of my work and education experience. I have done everything from representing landowners in oil and gas leasing to surface agreements to right-of-ways to all sorts of that. I've also represented the oil companies on the same things, both as an independent attorney, landman, and in-house.
Okay, thank you for that. Mr. Williams' testimony today is as a fact witness and not as an expert witness. We'll go to our first exhibit here, which is kind of our 30,000-foot locator map. If you can please describe what's depicted on here.
All right, this is a depiction, first of all, as a regional map to show you kind of where we're talking about here, and then more specifically in the larger area there. This is our prospect area. It encompasses an area just south of Duchesne City. It's almost a full section, or I'm sorry, almost a full township. The wells that we're going to be talking about today are within this area here. When we do a full total development of this area, there'll be quite a few more drilling units than just what we're talking about here today.
Okay, and that puts us in the box there, and so now we're going to zoom in on Exhibit B, and I think now is a good time to ask you a couple of specific questions before anything else you have to add.
Okay.
In terms of this request for agency action, did you send a true and complete copy of the request for agency action to all working interest owners and unleased mineral owners within the 6 areas here, each marked with a different well name?
Different well. Each one of those is a drilling spacing unit, and yes, we sent a copy of the RAA and a notice of this proceeding to every working interest owner and unleased mineral interest owner in each of those 6 drilling spacing units.
Okay, and to your understanding, the formal notice of hearing was sent to that same group of people by the board, and also published by the board in 2 newspapers of legal circulation?
Yes.
Okay.
We got a notice of mailing from the board, and then also the notice of publication from both the 2 different newspapers.
Okay. And do you believe that notice, collectively provided appropriate notice is required by Utah law in terms of the persons whose legally protected rights may be affected?
Yes.
Okay. So looking now a little bit closer to Exhibit B, if you could please describe what we are showing here to put the board in the right area as to the specific wells we're talking about.
So each of these named areas here are drilling units that are based on the spacing allocations that were given. We have 3 3-mile spacing units there: the Collins unit, the Black Buck unit, and the Bongo unit. We also have 3 2-mile spacing units: the Lee, the Nilgai, and the Gemsbach. There is 1 well that has been drilled in each one of those drilling units at this time. And I guess that's about all I need to say.
I think so. And just for the board's edification, these areas are the areas that where we cleaned up the well spacing in our rather large request for agency action last year.
A few months ago, we cleaned up and made one spacing order that covered all of these here. Let me tell you one other thing here. Although these depictions are just graphical depictions, the Lee Collins wells are on 1 pad, and the 4 down, the Black Buck, Bongo, Nilgai, and Gemsbach are all on 1 pad. So that's a common pad of
And that's this
production on
red?
both of them. That's essentially where the red is on the paper there.
Or the single pad, so.
Yeah.
Yeah, and my point was that we're, WEM is using what you've given them already, so.
That's right.
Thank you again for the last RAA. We will now move on to Exhibit C. And if you could describe and kind of walk through this, I think the board really needs a good understanding of respecting the fact that Mr. Treek may end up having to answer some of this, how we got here and what, and the efforts that WEM is taking to resolve the gas takeaway issue, and also how this may be impacting royalty override and other similar type of owners.
Okay. I'm sorry.
I put that slide together if you want.
You did this slide?
Yeah,
Okay.
if you want me to. It's up to you.
Let me answer the first question, is how it impacts royalty and override, and then
Okay.
I'll probably hand this off to Dustin to
Okay.
work through what we have been doing and how that impacts there. So the essential answer, I believe, the point that we're trying to get to with this is that the gas flaring that we're doing right now has absolutely no impact on royalty overrides. It will have an impact on our participating working interest owners because we're not selling gas at this point here. But all of the royalties and overrides are going to be based on produced gas, not on gas sales, because there are no gas sales at this point here. So we want to be able to protect the correlative rights of those royalty owners and override owners. Of course, we do have some tribal mineral interests in here, which that's a requirement anyway. It doesn't matter whether we flare them or not, we'll pay a royalty on that gas. But we plan to do that for all of our royalty owners, is if the gas is produced, it will get a royalty payment on it.
And so it's, all of the flared gas obviously is being accurately metered, correct?
Yes, that is correct.
And so all non-cost-bearing parties are still getting paid their royalties, and that expense is falling solely on the working interest parties.
And that is correct.
Okay. I don't have, recognizing that I think it's going to be easier for our engineer to answer some of this. I have no further questions for Mr. Williams.
Division, do you have questions?
So you just indicated that non-cost-bearing owners will receive royalties. Have you had any feedback from any other working interest owners or cost-bearing parties on your proposed flaring?
We have not had any feedback at all.
Okay. Yeah, no further questions from Mr. Williams.
Mr. Moon?
So you're paying royalties on the flared gas. Is that because you're required to, or just out of the goodness of your heart?
So the easy answer on that is because it makes the accounting easy, because we have to pay it on Indian. So our tribal royalties will bear that. So rather than trying to break that out between the two, it's a matter of convenience. Plus, I think it's probably the right thing to do.
What percentage working interest does WIM have?
In the Gemsbach, we're 100%. In probably the easy way to answer that without having the papers in front of me is that we are an 85 to 95% working interest owner in each of these drilling units, except for Black Buck and Bongo, where we do have some other working interest parties. We have about a 60% in there. Barry is in those two wells. Rig 2 is in those two wells also.
So this is pretty much a corporate decision to pay
Yes.
the royalties. Okay. Mr. Church?
So is this gas that's flared at the wellhead, or has it gone through a separator and then flared?
I'm going to leave that to Dustin to answer. I believe that it goes through the separator first.
Okay,
But
well,
if I'm wrong, Dustin will correct me.
Okay, and I'll check later at GOR. I just wanted to get a feel for what that is.
Sure.
Mr. Walker?
Yeah, okay, so if you guys could check me sometime during this, I just ran rough numbers at 1.1 million a day, 6 wells, 30 days. That's around 200,000 times $2. It's about $400,000 a month. That revenue that you're giving up,
That sounds right to me.
and 20% royalty. So you're losing about you're gonna have to pay out $8,000 in roughly in royalties, 8 to 10,000.
That sounds right to me.
Okay. And all right. That's the only question I have.
We feel it's really important to keep the wells flowing, that by shutting in these wells because we don't have the infrastructure that we would like to have here, could be detrimental to the production of the well in long term, and we're willing to absorb that cost. I was gonna say minor cost, but it really isn't a minor cost, but we're willing to absorb that cost to make sure that we got that. Plus, we're learning every day, as Dustin will explain. We are learning more and more about these wells that will help us in our development plan. And we believe that would be detrimental if we had to shut these wells in both the education and not only our education, but our neighbors who are also watching what's going on here and that we're in communication with as we all jointly develop the assets in this area here.
Are these high pressure? What's the pressure, producing pressure? You know?
Yeah, I'm gonna let Dustin answer that.
Okay. Okay.
So, yes, I do believe that they're that they're overpressured, but not significantly, I don't believe. But I'll let ask that question in a minute.
And are you drilling any more wells out
We are.
there right now, or are you waiting?
We have drilled
pipeline
4 other wells that we're now completing. We will complete those shortly. We're hoping to be able to have corrected our infrastructure here by the time those are up and running totally. And I think, I don't know if I'm speaking out of turn, but we expect to turn those on sometime in May. With that, we have not, we specifically slowed down our drilling program over the last 6 months for this reason, so that we could get infrastructure caught up. We will begin drilling, we hope, the 1st of June, which will get the rest of, or get our development up and running again. Hopefully by that time we'll have a hard line of when we're gonna have complete takeaway for what we now expect, which is much more than what we originally expected in this area here. But we do have some long-term plans that, and when I say long-term, 6 to 9 months, plans of building out an infrastructure that will be an adequate access for this gas.
And this is probably a question for the next witness, but this is, there is a pipeline in the area. This is a pipeline expansion. They're extending lines. Are you rebuilding an existing line?
So we're doing multiple things right now. There are some existing lines in here. Scout has a takeaway that we currently utilize. We thought we would be able to take more than that by doing some compression, do more than what we are on our 5 wells that are still producing right now. Those go into a Scout system. We're hoping to maybe add some compression to that and be able to take more away. We're looking to tap into a line that Barry owns that's right next to our area here where our takeaway would be. With that, again, we've got some compression questions, and now that Scout is starting to build out more of their horizontal program and Barry's entering into their horizontal program, we're seeing some reluctance of them giving up space. They're reserving that space there. FourPoint, who you guys met this morning, has a small gathering system that we think that we can utilize. And we're in discussions with them of being able to utilize that, at least on a short term, as on this area here, because this is an area that they are not really focusing on right now for development, except for lease saving. Although there's been a lot of development by them here. Ultimately, I think we mentioned this here, and I call it the Williams Tap, is about a 9-mile pipeline, and Dustin may speak more about this here. That's the one that we think will take six months to a year. to the east where we can tap into a transmission line. That will be our ultimate solution there. So we're looking at some interim solutions, some immediate solutions, some interim solutions, and then a final solution if we're looking at this.
Thank you. Board, do you have any further questions? Mr. Walker?
Yeah, maybe this next witness, but are you building out the gathering system, or are you relying on others, or combination thereof?
So ultimately, our sister company, our affiliated company, Rewater, will build out that system. But there are other components as we're using the FourPoint system, the Berry system, and the Scout system that we will be working in combination with them to utilize their systems there. But most of the pipeline, if not all of the pipeline that will be built by our affiliated company, Rewater.
I think that's it for us. Do you want to proceed?
Okay.
Thank you.
Absolutely. I will call my next witness, Mr. Treek, who is WM's Chief Operating Officer. I've put his resume up here, but I'll ask you to nonetheless introduce yourself and your current title, and then confirm that you have provided evidence to the board in the past on multiple occasions as an expert in petroleum geology and reservoir engineering, petroleum engineering.
Good afternoon. I'm Dustin Trike, COO, Wasatch Energy Management. Been before the board a couple times, spacing hearings in the past, both with a couple different operators. Started my career with Crescent Point, worked the Uinta Basin out of their Roosevelt office, and then out of Denver, their corporate office. Had the chance to join the CH4 Finley team when they acquired the Utah asset from Crescent Point. So I went down to Texas, joined that team, working the same asset. Worked out of their field office for a period of time, and then joined Wasatch in 2023.
Okay. And you have provided testimony as an expert witness in petroleum engineering and reservoir in the past to the board?
Yes, sir.
Okay. Subject to any voir dire by the board or the division, I would offer Mr. Trike's testimony today as expert testimony in petroleum engineering.
Division, do you have any comments?
Yeah, no objection to that.
And board? So accepted.
No objection, but I know I asked this question last time you testified, but educational, that's not on the resume there?
Yes, sir. Yep, I studied geological engineering at the University of Nevada and got a bachelor's degree in geological engineering.
Okay. So we'll move on to Exhibit C, which we had shown a little bit earlier. But maybe I'm going to ask you a couple of questions here to hit on some other questions. The first one was wellhead or separator?
All the flared gas will go through a separation process and then go to a high pressure flare, so it is separated at that point.
Okay.
Right around 1,300 BTU content, so it's a relatively hot gas. We're seeing this is pretty common with the Uteland Buttes in this area. We're definitely seeing a wetter composition from a gas standpoint.
And there was also a question from the chair regarding these high pressure, are they overpressured wells?
Yep, we are overpressured. I wouldn't describe them as extremely high pressure like you would see in the deeper part of the basin, but a typical flowing pressure for us when we bring a well online is somewhere between 1,000 and 2,000 pounds. So I would still classify them as high pressure wells. They'll naturally flow for a period of time when we bring them online, anywhere from 60 to 100 days based off of choke strategy.
Okay. And so with respect to Exhibit C, if you could describe to the board and supplement as needed the current well operations and the future development, and if you could include in that discussion the other wells that were mentioned by Mr. Williams that are they're in completion status right now and may be coming online towards the end of May 2025.
Yeah. Okay, I'll start on the left side of the page with our current well operations, a little bit of history. We drilled 6 horizontal wells at the end of 2024. These were a combination of 2 and 3 mile laterals. We've since brought the wells online. The production has exceeded our expectations. That's great for us as a team. The unfortunate thing for us as a team is that from a pipeline capacity standpoint, we've exceeded that point. We want to sell as much gas as possible. We don't want to flare. In our current infrastructure, and I think one thing I should highlight here, all of our pads are currently connected by a 20-plus mile network that is our rewater infrastructure. We haven't drilled or completed a pad that doesn't have pipeline attached to it. We have a buried, robust pipeline network to every single one of our pads. The issue isn't so much that our pipeline can't support it. The issue is I don't have an offtake for that gas downstream of me. And so if I don't have an offtake for the gas, my pressure in the pipeline rises due to the gas volumes, and then it backs up to my treaters, and ultimately it chokes my wells. So we've invested a ton into our infrastructure to handle this type of capacity. We just haven't. We've run into roadblocks and hurdles trying to get the gas out of our system. This same system supports all of our water, by the way. So we're currently moving 10,000 barrels of water a day via pipeline off of all of our pads. So when we talk about the initial watermelon development with those 5 wells, they're all connected to the same system. The water that leaves my furthest west pad will pass right by my eastern pads and then into our rewater facility. We take that water, recycle it, and use it for frac. So it's all one big system, and these pipeline bundles have gas and water capability. I think moving down this list of the current well operations, we've identified additional outlets for this gas. We just need additional time to complete the tie-ins. We're in the early innings of our project here. This acreage was considered speculative 12 months ago when we made the acquisition. And, as a technical team, we are ecstatic with what the well results look like. It proves our thesis that the basin is bigger than we thought and that the horizontal capabilities continue to extend, in this case, south and west. This production data is critical to WEM to keep these wells online so that we understand the capability and we can build a development program and have a sustainable program and grow our production profile here. We don't want to shut the wells in. The last thing you want to do with a early stage flowing horizontal is shut it in. We want to protect our proppant pack and keep our reservoir flowing at us for as long as possible. So I've hit that there with choking, like shutting or choking in the wells is detrimental. And then finally, WEM as a company, we don't want to flare gas. It is not a long-term strategy. We want to get this gas sold. We want to find outlets for it, and we're working feverishly to get to that point. And credit to our neighbors, we've leaned on them heavily to take our gas in the short term. But it's really exciting to see is our neighbors are picking up rigs and drilling horizontally now, and I think a huge part of that was our success. They're partners in a lot of our wells, so they're seeing the data, and we're sharing things like frac water and gas infrastructure. So this part of the basin has truly been unlocked, I would say, in the last 6 months. A little bit about WEM. I'll go to the right side of the slide for future development. We our specialty, or I guess our niche, has been finding opportunities on the perimeter of the basin. This is a completely consolidated basin. Finding operated acreage is really challenging, but we've been able to find those opportunities on the perimeter and take risk and drill wells and prove up acreage in places that people would have thought was not prospective. For that reason, though, there's no existing infrastructure that can support the horizontal development that we have planned. We started from scratch from an infrastructure standpoint, and we've built 20 plus miles worth of this pipeline network already. And I'll highlight that on the next slide to show you guys what exactly I'm talking about. But where you see vertical development in the Uinta Basin, the infrastructure to support these old vertical wells is completely different than what I need to support a horizontal pad. Most of these vertical locations don't even have water on pipeline. The scale and the volume that we're flowing back from horizontal wells, you have to have your water on pipe. You need to have steel gas infrastructure that you can support higher pressures of gas. Your typical vertical infrastructure is low pressure poly systems that at this point, it's totally insufficient for horizontal development. And, you know, we're committed to growing our infrastructure network, and we're committed to growing our production in this part of the basin. So I'll cap that slide with that point.
And I will go ahead and ask, you know, one other question that should be abundantly clear, but, you know, making these decisions, creating, you know, pipelines and hooking in the water, you know, this is also minimizing impacts, right? Because you have a lot of truck traffic that is non-existent now because you are actually moving your water around by pipe rather than having tanker truck after tanker truck.
Absolutely. Our pads are full of crude haulers. We're never going to get away from trucking barrels in this basin just because of the quality of the crude. But if we were relying on water haulers to haul the amount of water we're moving, it would be almost impossible logistically. Just you can't get that many trucks in and off of a pad. It would be too congested.
We'll move on to Exhibit D, which is kind of showing our system out there, but if you could please describe it, and I can point to anything in here if there's a specific spot.
So this is our rewater pipeline infrastructure map. I mentioned on the previous slide that we have 20 plus miles worth of pipeline that's already built. So that is here in green. So anywhere where you see a green line, we have a buried gas and water infrastructure line. All of our pads are currently tied into this network. Our challenges are at the termination point of our network, which is that rewater recycle facility. It's at this point where I need to get gas offloaded. We've got 3 different connections highlighted on this pad that we're actively chasing. I'm going to focus on the Williams-Brundage connection. That's the furthest east. I'm sure you guys have heard of Williams. They're one of the largest midstream companies in the lower 48. They have a huge interstate pipeline network here in the Rockies. They've been a great partner to work with, trying to find a home for our gas. They have available a gas capacity at their Brundage tap. But one thing worth mentioning is that you have to get across a federal surface. So we have right-of-way challenges to get to that point. And that's also a high-pressure transmission line, so we need to upgrade our system to have compression set, which we've committed to the compression, and we intend to have it set in the next 60 days. So that's our most actionable long-term gas solution. And in the meantime, we're working on more short-term solutions with our neighbors. And every week we have new information. It's a really dynamic situation. I'll highlight the furthest west one, the Berry Section 7 compressor tie-in. That was a short tie-in. We anticipated having that operational for that goat pad coming online. And we ran into DWR surface that had a 12-month lead time on the right-of-way. So that just completely kills that project for us. If I can get to Williams in 6 to 9 months, I'm not going to wait for Berry Section 7 to come available to us. And I want to mention this too, so the Berry guys have been great to work with. They're partners in a lot of our horizontal wells, and they have helped us a ton moving gas, and we're working with them on the water side too.
I'll move on to Exhibit, I think that's the last one. Yes, our last Exhibit E, which is just showing projected production growth, but I'm sure you can say that more eloquently than me.
These are all of our recent production numbers. I wanted to put this on a slide to illustrate the type of production growth we're seeing just from 6 horizontal wells. So you can see we brought on the first 2-well pad at the end of November. The green line is oil, the red line is gas, and then the dashed dotted line is the well count. Our production profile jumps up to 8,000 gross barrels a day at the beginning of this year, and gas trails right behind it at 6 million a day off of 6 wells. So as a technical team, we're high-fiving about this stuff, but as a production and operations team, this is a problem from a gas standpoint, and oil and water. We are doing our best to handle these volumes, and it's very encouraging for the acreage, but the type of infrastructure you need to support this type of development off of 6 wells is a complete step change, and we started from scratch, and we just need time to make the appropriate tie-ins and continue to support our development.
I have no further questions for Mr. Trike.
Division, do you have questions?
Yes, thank you. So when you first drilled these wells and completed them, well, I guess even when you first started drilling, what was your intent of the gas at that point?
Our intent at that point was to get as much of our gas as possible into Scout and Berry system, and we were going to bolster our connection into Berry with the Section 7 compressor tie-in.
And that wasn't possible just because of size of the gas that was being produced? Or?
It's still possible. The issue we ran into was that from a right-of-way standpoint, to get the pipeline across, I believe it's Section 5, that surface is DWR surface that required it was a 12-month delay on the right-of-way timing. So what we thought was an easy connection quickly turned into, oh, this is a year delay.
Okay. So in your slide, I think there was a reference to it in the REA. There was as well. There's discussion that choking back or shutting in the wells will damage the reservoir. Could you speak a little bit more to that?
From a damage to reservoir standpoint, when we go to complete a well, we're pumping a combination of water and sand. We're fracturing the rock, and we're propagating those fractures open with that sand. You have a finite period of time for when that sand is effective and creates permeability to when it crushes and shuts off a fracture. So we don't like closing in or shutting or restricting wells that you just invested $10 million into for a drill and complete. You're potentially harming all of that prop impact, and it can harm your reservoir.
Okay. So the original request was 2,500 MCF. We're now at 33,440 MCF. So we're looking at over 1,000 MCF, 1,100 MCF a day. Based on what you're seeing currently through your wells, is that number going to be sufficient to cover the flaring needs in the next 2 months?
Yeah, it'll be sufficient for the next 2 months. And our hope is that we can have either decline from the wells. I mean, I hate saying that I want decline on the wells. I don't. I want the wells to be flat for forever. That's not reality. They will decline. And B, we should be able to offload portions of this gas to quicker connections. Granted that we won't be able to have our Williams connection operational in the next 60 days, but we will have our compression set, and we'll have the ability to start sending some gas to Williams via Berry's pipeline infrastructure.
I'm going to ask you a couple questions now in relation to conservation methods that are suggested in the division's rules when subject to flaring. In the RAA, you indicate that WM has evaluated some of these methods. So I'm just going to mention them, and you, if you're able to, just let me know why these would or wouldn't work. And excuse me if I'm ignorant, if these don't even apply, let me know that too. So the first one was reinjection of the gas.
I simply don't have a place to reinject it to. Our asset is all brand new horizontal wells. If reinjection also includes gas lift, yes, we actually are doing that as well. So our primary artificial lift method is gas lift, but one thing I will mention is you're just recycling that gas. You're putting it down the casing and it comes right back up the tubing. So it unfortunately doesn't, it's still 1 + 1 = 2. Like it doesn't eliminate the gas.
Okay. Compression, it sounds like you have some form of that already in place.
Yes, so we've committed to it. It is not operational at this moment, but it is on the way.
Okay. Gas to liquid is another method.
Gas to liquid, I don't exactly know what that would mean. If that means just liquid capture like at a slug catcher, we're currently doing that.
Okay. Gas to wire. I'm not sure what that.
I don't know what that means.
Okay.
Yeah, I don't know.
Use on leasehold.
We're doing that.
Okay. And then pipeline alternatives. It sounds like we already addressed that. So, all right.
In regards to the flare gas mining, though, that's an interesting one. We've engaged in those conversations, but unfortunately, in this situation, that's also a big infrastructure project. There's lead time on all of the generators and the miners and the mining containers to support that. And those guys also, from an air quality standpoint, they generally get held up at that point trying to get those mines set up. So no, we are welcoming to those conversations, and we have one ongoing with a flare gas miner operating in the basin.
And I know you talked about reservoir damage. Is choking back the well, will that also, in your opinion, cause reservoir damage if you were to choke back?
Potentially. I think for us, just being in the early innings and trying to build our development program, seeing the wells at their full potential and capacity is paramount for us as a team right now. We're still in the process of trying to raise capital and have justification for additional infrastructure spend. Having the wells at their full potential is very critical to WEM right now.
And lastly, so you have a request to flare this much. I believe I heard there's 11 wells in this field right now. So what, just in your estimate, what amount of gas are you proposing to be flared compared to what you're actually able to sell or utilize at this point?
Just over 50% is being flared.
About 50%.
And then the other just under 50% is being sold into our neighbors Berry and Scout system currently.
All right, thank you very much. No further questions.
Board, do you have questions? Ms. Sierra?
You mentioned you had some challenges on the rights-of-way on Federal from, I guess, to Williams.
Yep.
Is it time constraints? Is it NEPA? Is it something that can be resolved sooner than later, or?
It's just time consuming. Applying for a right-of-way across federal surface, it doesn't matter if it's 300 feet or 6 miles. You still have, like NEPA is obviously a big hurdle that you need to clear. I'm sure that there's paleo and other ARC surveys that need to get complete. But another component to this is just the surveying time. When we're trying to build a pipeline, we obviously want to do it in the most efficient way as possible, and you're going to go through iterations with your surveying company to get a plat of that exact route. But I think the easy answer here is when you're crossing federal surface, it is time consuming. If that was all fee ownership, we could cross it relatively quickly.
These red and green lines you show up here are existing lines, is that correct?
Green is existing, built, and operational.
Okay.
Red is in the planning phase.
Okay, so that is not built.
Not built.
Okay. Mr. Walker?
Yeah. Can we go back to the production curve, please?
Oops.
Are the units here, is this, okay, so it's 8,000 barrels of oil per day for the field or per well?
For 6 wells.
For the 6 wells. Oh, okay, so that makes sense then.
Yep.
All right. J per 6, okay. And so the 6 million a day, you're gonna, yeah, actually, if you're asking for 1.1 million per well times 6 wells, that's a higher percentage than 50-50, I think, isn't it?
This is only 6. We have another 5 wells that are online.
Okay,
Yep.
so this
and those,
is
these are just the 6 that we drilled at the end of 2024. Okay. So I was trying to.
So the other 6 wells, you already got them tied in. These 6 or these 5, these 6.
The other 5 are tied in through a sales. They're not illustrated in this chart.
Okay, that makes sense then.
I was just trying to illustrate with this chart mainly is what 6 wells in a short period of time can do to your production profile. That was 8,000 additional barrels that we needed to find a home for in that. And we anticipated that the wells would be good, but as a technical team, we're really excited about the results we're seeing on the perimeter.
Okay,
Good
so
and bad.
just when you produce a chart like this, if you could define the x-axis better so that I didn't know what that meant. Okay, but it's 8,000 barrels of oil per day for all 6 wells that we're talking about today.
Yes.
Okay. And now I threw some numbers at Mr. Williams. where I was talking about $400,000 per month of revenue that you're going to forego for 500,000. Am I at least order of magnitude correct there?
I think so.
Okay.
I believe you are. One thing, there's a rule of thumb for us is we're looking at well economics. From a value standpoint, these are oil wells, and from a value standpoint, 98% of the value is in the oil and about 2% in the gas. And that can be a little bit, because you're probably wondering, like, well, if I'm selling this much gas at $2, the problem is by the time you get your gas transported and processed and into a downstream outlet, the differential you're seeing on the gas and the processing fees are pretty stout. So it's just, in this basin in particular, the oil is way more valuable.
Yeah.
Are you trucking that oil? I'm sorry.
I also, of the understanding, you have to have this test data so you can size your infrastructure going forward. So, okay. That's all I had.
Are you trucking this oil?
Yes.
Okay. Mr. Church?
So you're asking for an extension to May 28th. However, you mentioned you're going to have an evaluation meeting a week before that. So I assume there's a lot of uncertainty whether that date's going to be sufficient for you to have resolved a lot of these problems. And what I'm looking at is I understand rig contracts that you're going to have to continue to drill. But you mentioned you're possibly going to be bringing some additional wells on in May. There's no damage to the reservoir if you don't frack the reservoir. So I'm asking why you're not going to put a hold on the fracking of the wells. Because this product, there's also, severance that comes to the state, and that product's going to be gone forever that you're flaring off. So is there any possibility of drilling the wells to meet your rig contract, but yet not fracking them until you resolve your takeaway problems?
Unfortunately for us, on the pad that we just had to frack, I've got lease expirations that require that the wells have continuous development. So I've got large tribal tracts that will expire if we don't complete them and bring them online.
Okay, but so is that going to be ongoing, or is it just for the ones that you'll be bringing on in May?
My 2025 drill program has the same problem. I've got lease expiration wells that have to get drilled this year to hold acreage.
Okay.
So there is uncertainty with our May 28th date that we have this all resolved. But we're working as quickly and as diligently as we can to find a solution for the gas, because unfortunately all these things are connected. My gas takeaway, my acreage expirations, I need the downstream takeaway to support everything we're trying to accomplish with the acreage. So we're going to work as quickly as we can to find a solution for our gas and have the ability to continue to drill our leaseholding wells and eventually develop this thing fully, which we believe there's over 100 economic locations likely across our WEM operating footprint now.
Well, I congratulate you on your success.
Thank you.
Mr. Church, I think I would add to that the dates chosen here, as I noted, we initially picked May 15th and then realized, then we've got 10, 12 days before the next board hearing. What if we need an emergency order? And so in large part, these dates are picked, and what we've talked to the division about is to get at that concern of, we don't want to come in here and say, let us just, flare like heck for the next 6 months or 12 months or whatever. What we're doing here is designed to keep the division and the board
gas revenue
consistently apprised within 30-day chunks of where we are in this continuum, what we've solved, what we haven't solved, what other new options might have come out, what the flaring amounts actually are during each one of those periods, so that we're only asking for what we need for the immediately foreseeable future, and then the division and the board have that opportunity to step in and say what they want to say, learn what they want to learn, and change things if that, if that need be, in smaller chunks of time, rather than asking for, we just didn't want to come in here and say, hey, the best option might be the Williams connection. We can hook everything into there. We need 12 months, or, that kind of thing. We didn't want to kind of overreach that. We want the board to be lockstep with us in terms of knowledge, and the division to be lockstep with us in terms of knowledge.
Mr. Moon.
So, so when you've laid the water, because you need the water first, so you just put the gas line in the same.
It's all
basically
one
in the
trench.
Same trench. That's
Yeah.
awesome.
Yeah, one trench.
So my understanding is you already have. It's not a matter of getting the gas line to the well. It's a matter of getting the end of that gas line onto. You're relying on your neighbors basically, and they're using up their capacity themselves, and so you've been bumped back. Plus, you have more production than you expected. So, just a quick question: the OVINTIV Ranch compressor station. I've always understood. I chase my cows around it all the time, so I see it. I always understood that was underutilized. Why isn't OVINTIV part of the solution here?
So they are. We're actively chatting with FourPoint about that, and the solution we're looking at with FourPoint involves that exact thing. So, yeah, our hope is to start utilizing that thing and pushing gas that way.
Yeah, because your line's just a mile from it, right?
Yes,
there,
exactly. Yeah. So our infrastructure is very close. We hope that we can make that operational soon. But one other interesting thing here too is, the FourPoint team just entered the basin. They've got big fish to fry, and solving WEM's gas problem is not at the top of their list. And so we appreciate their support and them working with us, but we also recognize like our neighbors are firing up horizontal programs or have them running currently. And so it's, the time it takes to build these relationships and get the infrastructure in the ground, it's time consuming. And yeah, so our hope is to continue to work on the FourPoint guys and get something moving that direction.
Well, I credit you for getting the water, getting all those trucks off the road and all that dust and all of that, because a lot of stepped out wells there's just so much truck traffic that, anyway.
That's been great. We actually just completed a 4-well completion that we were chatting about, that those are the wells that come on in May with the lease expirations, but that was our highest percent of recycled water we've ever used. We were at over 70% recycled water. So it's there are some definitely nice wins that we've had on the infrastructure side. It's just gas is short-term pain for us right now.
You just need to figure out how to blow that frac sand through a pipeline and get it there.
Well, they're doing that.
Trucks.
They're doing that in other
Oh,
basins.
really?
We're going to try to find a way to do it here. Yeah, if we can get the mines closer to the wellhead, you
Yeah.
just move it in a slurry.
Yeah.
So
Oh,
yeah.
you put it in a slurry and
Exactly.
then dry it back out, or no? You
No, it just keep it wet.
keep it wet.
Yeah.
Okay.
So yeah, benefits of having your
Like
sand mine next
the
door.
oil.
Yeah.
You got to keep one hot and keep the other one wet.
Yeah.
I got one more question. On his 33,430 MCF per well, are you going to aggregate that across the 6 wells? Or are you going to be, when you hit 431, are you going to stop and shut in this one well? Or are you going to?
We would aggregate it across the wells for the reason being that they don't all exactly have the same production profile.
Okay, thank you.
They're close, but I've got 3-milers, I've got 2-milers that they're different profiles.
So the 1.1 million, or this roughly 6 million a day is what you're going to be.
It felt like a good average.
Okay.
So it's a curiosity question. You mentioned 3 miles. So you get about a 1/3 bump in production on a 3-miler versus a 2-miler?
We're not quite seeing it at 1/3. Early life, it looks very encouraging. I think that there's been folks on both sides of the argument that, but our approach as a team and what we're seeing is that the 3-milers early life, we're seeing additional production out of that 3rd mile, and that just more than helps justify the economic case to go the 3rd mile. So, no, we're very encouraged early life. We're seeing our 3-milers are outperforming our 2-milers.
Any further questions? What diameter is this pipe you're putting in for the gas line?
So we have a combination of 8-inch and 12-inch in the ground already. We've moved to 12 on everything obvious reasons. We're getting more gas and need to move more, so we've jumped up to a 12-inch, and then our water infrastructure is 2 6-inch lines. We run 2 of them parallel. So yeah, and then we have a residue system which provides dry gas back to the wells, and that's 6-inch. So it's a big pipeline. Our pipeline bundle is pretty robust. It's a large system, and it's designed to support all the horizontal development. You'll notice, the green lines. The reason that we have it consolidated to one is that acts like an infrastructure highway, and I drill wells east and west off of that point. So it consolidates you down to one infrastructure corridor. Over time, as the rig reoccupies pads, I get the savings on the infrastructure that we invested the first time around. And then my rig can drill in 2 different directions, and it's all one highway there for the infrastructure.
Do you have all the rights of way you need except for that federal piece?
We do. Everything in green, we've got sewed up. We own a lot of the surface at this point, and then we also, the landowners have been great to work with out here, and we've been fortunate to secure the right-of-ways across that. But the red is where we don't have it.
Okay.
Could I just ask a side question to that? You indicated there was a 12-month delay in Section 7.
Yes.
Do you know what that delay is?
My surface land team would knock this question out of the park. It is related to, and Larry, correct me if I'm wrong, I think this acreage, when it was deeded to DWR, it came with a clause of if it's right-of-ways assigned to pipeline, it requires a full NEPA process, and so that's our assumption, is that it's...
So, as I understand it, that particular section was a grant from the federal government to DWR, and it did require a NEPA process for any surface disturbing activities. We did not know that when we first were working through this, and only found that out just 2 weeks ago, I think it was. We went, there's another hurdle, which has kind of been par for the course in every one of these takeaway scenarios, as we get really close and then hit the hurdle.
Thank you.
So you don't have any other federal land along that red line that you...
No. To the east, where we're crossing a little bit of BLM land over there, we do, but otherwise it is almost, I'm going to say it's all fee.
Is that going to delay you if you're having to cross BLM land?
For the Williams line, that we're taking that into account to do the NEPA for the Williams line, and it's only like a mile and a half of that, but doesn't matter whether it was all 7 miles or 1 mile. Right. You do the same process.
Right.
We're actually going to jump into Barry's pipeline to get to Brundage sooner, and then we're going to build our own pipeline as our volumes grow. So they fortunately have an operational pipeline across all that federal surface. We just need to pressurize our gas and get it into that high-pressure transmission system.
Well, it sounds like it's an exciting new project here. Mr. Walker.
Yeah, I just want to clarify, DWR, that's the Utah Division of Wildlife Resources that's
Yes, sir.
holding that up. Okay. And then on this Exhibit D, that build-up area up in the top left-hand corner, is that Duchesne?
Yes, sir.
That is town of Duchesne. Okay,
Yep.
thank you.
Do we have any further questions? I think we're back to you, Mr. Chicken, for summary.
Well, I'll be brief. I think everybody has a very good idea of what's going on here. We are asking to flare 33,440 MCF per well per month in the aggregate for the 6 wells identified in the RAA from today, which is also the day that our current division extended. Thank you very much. Flaring exception expires from today through May 28th, 2025, which is the date of the May board hearing, subject to an express requirement for folks from WEM to set an administrative meeting with folks from the division sometime in mid-April in order to provide an update to the division folks in terms of where we are in the process of getting the infrastructure put in, how we're doing on getting rights of way, providing the actual, the hard numbers of gas flared between what we've put in our RAA and that date in April. And this would also include an obligation to appear at the May 28th hearing before the board in order to provide yet another update and potentially ask for, either say, hey, we're really close, or we're there, or we're not there yet, and we need an additional extension. And again, as I mentioned earlier, that way there's no chance, and I think we get it at a division concern, which is that this, becomes some kind of gimme runaway type situation. That's not the case. It's to my untechnical mind, it's pretty simple. We drilled wells that were way better than we thought they were going to be, and we are now scrambling and doing everything we can to capture that gas. And we are making, royalty owners whole. And by the way, Larry, the right answer earlier was yes, from the goodness of our hearts. No. But in any event, that is what we are asking the board for today. We believe the division and the board's counsel are accepting of this, but I don't want to put words in their mouth. And we would request that with those modifications and under the limitations I just stated, that a request for agency action be approved today.
Okay, Division, do you have any final comments?
Yeah, we did have some comments. Thank you. So, we're here today because of this request for flaring. I mean, these requests aren't very common before the board. I think we've had 4 in the last 10 years, something like that. But that's for a good reason, because under Utah Code 40-6, waste is strictly prohibited. And waste is also defined under the code as production of oil and gas in excess of transportation and storage facilities. So the board has a matter before it where we're asked to look at allowing waste. But waste is also operating a well that will also damage and limit the ability for that well to produce to its fullest capacity too. So we come before you because we have flaring that will hopefully allow more production, and that's what WM has presented before us today. When we initially got this request, it was a small number, 2,500 MCF, which only comes out to be about 23 MCF a day above what they're allowed to do without approval anyway. So it didn't raise much concern. When the number was bumped up significantly, we did have a little bit more concern. And the concern isn't necessarily with WM and what they're proposing. It's more just a policy of we don't want operators thinking, hey, we can just come and drill wells without the infrastructure in place and then just ask the board to flare later on to bail us out of this prohibited waste that we want to enact. So that was our concern here. After hearing WM's presentation, talking to them, we don't feel that's the case here. They have a great plan. They had wells better than expected. So I mean, we're not in opposition of what they're asking here today. And as Mr. Chicken pointed out, as long as we have that caveat where WM comes back in 2 months and presents what they've flared, where they're at, and what they want moving forward, we feel like that accountability to continue is necessary just to have a standard there as these matters come before the board later on.
And this is just an interested question, I guess. What about air quality with flaring that amount of gas? Do you have air quality permits that you have to get, or any air quality issues that you're aware of?
Our understanding is that we're working directly with UDOGM regarding the flaring. I'll follow up with our team in terms of the air quality component, but our understanding is that it's governed by UDOGM.
It's partially, the DEQ also has some rules regarding flaring, but I think my understanding is if it's necessary for producing the wells, as long as you're flaring it and not venting it.
Right.
But I would also communicate with them to make sure you have all of your ducks in
all your I's dotted.
Absolutely, we will. Thank you.
Yep. Board, any final questions or comments? Okay. Let's admit the exhibits.
I was just going to ask that. I would like to request that exhibits A through G be admitted to the record.
Yep, no objection.
Seeing no objections, they are admitted. Board, do we need to deliberate, or are we ready to make a decision on this matter?
This is big enough. We ought to go talk about it for
Okay.
10, 15 minutes.
Okay. We're going to adjourn until about 2:25. And we'll be back with you. We're off record.
Thank you.
Good afternoon. We are back on the record, and we have, I believe, a motion on this matter.
Yes, I'm going to make the motion on this matter, but I also want everybody to know that this does not set a precedent. Wouldn't expect that this motion is going to be similar on May 28th. So keep that in mind. Make all sorts of contingencies. Make your preparation. Get ready for things. So with that, I make a motion that we approve the request for agency action as requested.
And do we have a second? Before we vote, is there any further board discussion on this matter? Are we ready to vote? Okay.
With respect to today going forward and looking at the extensions of adding more capacity, like to the Williams line, we talked a little bit prior to the recess moment that we had. Are you already engaged in the NEPA process, and do you have a timeline as to when that's going to resolve? Because we're trying to get a sense of how quickly you can resolve some of the issues that are before you, so that you don't have to come back again, after the May 28th deadline. So is there an expectation of resolving some of these challenges in the next 2 months, and what that timeline looks like?
Yep, so the solution into Brundage, there's two components to this, and I should have highlighted this better. Barry has an existing pipeline from our rewater facility to that Brundage tie-in. It's a high-pressure transmission line. The only thing we need to get into it is a 300-foot right-of-way, which we've already submitted. It's just an amendment to an existing right-of-way. And we need compression to get into that line. That is a shorter-term solution to move about 10 million a day worth of gas. So that is our number one priority, is to piggyback onto Barry's pipeline spare capacity and get to Brundage. In the meantime, we have kicked off permission to survey, and we're in that phase of trying to plan our route from Rewater to that Brundage tie-in so that we have our own pipeline. And the justification for our own pipeline is we're going to need our own pipeline to move our own gas. Barry is currently drilling horizontal wells. They're drilling their first pad as we speak. Over time, they will kick us out of their system because they're going to need that capacity for their own program. So we will be able to recycle all of the compression we're going to build out to tie into Barry. We're just going to utilize it for ourselves from that point forward. So no, we haven't quite started the NEPA process on our pipeline, but we are going to we're leaning on Barry in the short term, and they already have a built pipeline that we're already tapped into. We just need an amendment to a right-of-way.
So your expectation for that short-term solution, if you will it take you to the 2 months, or is it going to take you beyond that?
It's going to be incredibly tight. If I had to guess today, it's a June solution. So we're very close to that May timeframe. But I'm hopeful that we can move quickly and get it addressed before. But I mean, my operations team would be sitting behind me saying it's going to be a June solution for us.
Mr. Moon.
So right now your drilling rig is laid down, is that correct?
We're not drilling as we speak, no.
And how much of that has to do with this gas problem, or is that just
It's a huge component to it. Yeah, it's a huge component to it.
Component to it. Okay.
Yep.
So you're delaying your program.
Yes.
To try to fix this before you add more production.
There's a couple other factors that are playing into that as well, but yeah, I mean, having the infrastructure dialed is a huge factor in why we haven't picked up and we're continuing to drill. We would just be ducking more wells, and as a small company, that's a no-no.
And so you're going to have to bring these 4 new ones on. Are there others awaiting that have been fracked that are ready to be, or even unfracked? Okay, this is
just those 4.
So it's just this is it
Yep.
for now, and then so you're saying you won't be drilling again really until there's a solution.
We won't be drilling till there's a solution, or at least we have much better line of sight. It feels like every 30-day increment, we know a lot more about the situation and have a better grasp on it. But if we start drilling again in June, we don't anticipate those wells being online until late September or October, just from a cycle time of the pads. So it's not one of those things where we start drilling in June and I've got wells to bring online a week later. It's in fact the opposite. It takes months to get that pad turned around.
Okay.
Do we have any further discussion before we vote? All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, the motion passes. I would like to just reiterate, extensions are not automatic, and I would encourage you to do whatever you can to accomplish this by May 28th. And that's it. Mr. Chicken, would you please draft the order?
Yes, Madam Chair, no problem.
Thank you.
Thank you.
Thank you.
And with that, do I have a motion to adjourn?
So moved.
Moved and it's done. We are adjourned.